located at 100 Cambridge Street in Boston, Massachusetts. Additional days of hearing are scheduled for later this year on October 21st, 22nd, and 23rd. We're continuing from yesterday with the appellant's cross-examination of the respondent's witness, Detective Lieutenant Kevin Dwyer. Mr. Moynihan?
Thank you, Madam Commissioner. Good morning, DLP. So I just wanted to go back to our appellant's Exhibit 19, which is APP 0107, first of all.
Correct?
Correct.
I'm there, sir.
All right, and so what we had there, sir, was a June 26th, to from, as you call it, from you to Lieutenant Colonel Shoemaker, correct?
Correct.
And we asked you yesterday what the purpose of this was, and I think we sort of characterized it as potential violations, and you told us that you were spitballing about potential charges, correct?
I wouldn't use the term spitballing, but yes, it was the possible violations.
I think
yes.
I asked you about spitballing.
You did.
You agreed with me.
You did.
Okay. And so, in this, you told us also that you're not responsible for the ultimate charges in these cases, are you?
Correct.
And that's up to someone else.
It is.
And who's that someone else?
Again, I'm not part of the process. It's the leadership in DST, along with the legal section, I believe.
Colonel Shoemaker?
He would be part of that process, yes.
And so you're drafting this email, I'm sorry, this to from before the mistrial and the relief of duty, and you are highlighting and potential charges, correct?
Correct.
But why would you do that if you're not responsible for the ultimate charges?
So again, I'm not responsible for the ultimate charges, but part of my job is to identify possible violations that directs my invest into what violations I should be looking at.
Right. And in here you mentioned 5.23, which we went over yesterday, was dissemination, correct?
Correct.
And Michael Proctor was not charged with that, correct?
I don't believe he was.
And you also highlighted and mentioned admin 18, bias policing, etc., correct?
The admin 47 for bias policing, yes.
Yes. And he wasn't charged with that either, was he?
So I'm not positive, but I don't believe he was, no.
Okay. Now, you're aware, sir, are you not, that Michael Proctor was ultimately charged with unsatisfactory performance?
Yes, sir.
You didn't mention that in your to from, did you?
I don't believe I did, no. No, sir.
All right, so somebody else came up with that, right?
Yes, sir.
Now, we discussed yesterday that we had some discussions early on, whether it was on the day of the duty status hearing or immediately thereafter, about getting Michael in for an interview pretty quickly, correct?
Yes, sir.
And you told us that nobody told you that you had to hurry this case up.
That is correct.
And in the normal course of an investigation, you would normally do interviews of witnesses first before a subject, correct?
If there were witnesses to interview, correct.
Okay. It's fair to say that a trooper is entitled to an interview as per policy, correct?
Yes.
And a trooper is entitled to an interview as per the collective bargaining agreement, correct?
Correct.
And in fact, he's entitled to an interview per those two sources before any conclusions are reached on an investigation, correct?
Correct.
And is it fair to say that your report, well, let me back up. First of all, after you conclude your investigation, you prepare a report, correct?
I do.
And that report is done after you've interviewed witnesses, if it calls for it, and the subject, correct?
The final copy is yes.
Because the subject might be able to offer important facts in the interview, correct?
Yes, sir.
And mitigating factors.
Yes, sir.
And it's actually a matter of due process, isn't it, sir, that a subject should be allowed to be interviewed before conclusions are reached about an investigation?
Yes, sir.
And we saw yesterday under the policy that the subject of an opioid investigation is entitled to all constitutional protections, correct?
Correct.
And all collective bargaining protections, correct?
Correct.
And could you turn, sir, to Appellant's Exhibit 52, APP 0336?
What was the page number again, sir?
APP 0336.
I'm there, sir.
Okay. So I think we went through this a little bit yesterday, correct?
Yes, sir.
And this is the general order, essentially the rules for our OPIA, Office of Professional Integrity and Accountability, correct?
Yes, sir.
And on page 2, it describes the procedure for opioid cases, correct?
It does.
And the normal process is that you prepare a report on the investigation for DST, correct?
Correct.
And we said yesterday DST is the Division of Standards and Training, correct?
Yes, sir.
That's the division that you're part of.
It
correct?
is.
And in your report, you provide supporting facts for each allegation, correct?
Correct.
And then a classification of the complaint, correct?
Yes.
And so the report is done after the investigation's finished, right?
Yes, sir.
And the findings, your findings, are presented in the report after the investigation is finished, correct?
Correct.
And so any sustained findings that you make would only be presented in the report after your investigation is finished, correct?
Correct.
And this investigation would include the interview of the subject, correct?
It would.
And it says in here again, and I don't want to repeat myself too often, but the report is submitted to the colonel of the DST, who is Lieutenant Colonel Shoemaker at the time of this case, correct?
Yes, sir.
And Lieutenant Colonel Shoemaker is the designee of the colonel, of Colonel Mott, correct?
Yes, sir.
And so in the normal course of events, you would conduct your full investigation, correct?
Yes. Yes.
Interviewing the subject, witnesses, and you prepare a report.
Yes, sir.
And after the report is finished and it's sent to Colonel Shoemaker, fair to say that the report is then reviewed by Colonel Shoemaker
Yes, sir.
and the legal department?
Yes, sir.
And in the normal course of events, if I'm the attorney for the trooper, then that report gets sent to me with a recommendation, correct?
That is correct.
And many times, negotiations take place between myself and the department, correct?
Yes, sir.
And a matter of fact, it's a small percentage of cases, is it not, where we have to go to a trial board?
So I couldn't speak to that, but that's my understanding.
Your experience?
Yes.
Could you, sir, go to Exhibit 27, Appellant's Exhibit 27, which is APP 0131.
Yes, sir.
All right, you there?
I am.
Okay, and so on APP 0131, we have an email, correct?
We do.
And that's from you to me,
Correct.
and that's dated Friday, July 12th at 3:22 p.m., correct?
Correct.
Friday afternoon. And you have attachments, subject, the second one is Trooper Proctor subject call-in letter, correct?
On the email page.
I'm looking at the email.
Yes, yes.
And then your email is, good afternoon, Dan. Attached to this email is the subject call-in letter for Trooper Proctor for 7/19/24, correct?
Correct.
I've attached transcripts we received from the court, as well as a summary I created. Let me know if you have any questions. If not, have a good weekend. Kevin, correct?
Correct.
So you sent me that on Friday afternoon on 7/12 at 3:22 p.m., correct?
Yes.
Who is Suzanne Caravaggio?
She is the department prosecutor.
Do you work hand in hand with her?
I work with her, yes.
Okay. And are you or are you not aware, sir, that Suzanne Caravaggio is the department prosecutor, was trying to schedule a trial board with me on the morning of July 12th before we even agreed to an interview date?
I was not aware at that time, no.
Okay, fair enough. Were you aware that Suzanne called me on Friday afternoon to discuss that?
No,
That same Friday afternoon?
I am not, no.
Were you aware of my email back to Suzanne on the following Monday, the 15th, concerning the irregularities of this?
No, sir.
Okay, fair enough. It's still your testimony, though, sir, that nobody at the department told you to rush this case along?
That is correct.
Okay. Zach, can I have, is it 29? Why don't you give me all 29, 30, 30. Could you, DLT, turn to Exhibit 29, please? Zach, I'm not ready for 235.
Yes, sir.
Are you there? So, Exhibit 29, APP 0140. You with me there?
What was the page number again?
APP 0140.
Yes, sir.
All right. And this is an email from you, correct?
Yes,
And it's to Bruce O'Rourke.
it is.
Who's Bruce O'Rourke?
At the time, he was the OPAA unit commander.
He's one of your bosses?
Yes,
Okay. The date of this is Thursday, July 11th of 24, correct?
yes,
And the time is 3:57 p.m., correct?
yes,
And the attachments are Proctor IAS 2024-0014 report draft, ... correct?
yes.
And so this is addressed to Captain and Goose, correct?
Yes,
Captain is O'Rourke?
it is.
Who's Goose?
Goose is DLT John Goslin.
Okay, that's his nickname,
It is, yes.
right? And so your email says, on July 11th, attached is the draft report for IAS 240014, correct?
Yes,
Please review and let me know any suggestions, corrections, changes. It has not been peer reviewed yet. For the interest of time in being able to submit it tomorrow. Goose, if you could look at it too. Make sure I didn't miss anything. Thank you. Kevin, did I read that correctly?
you did.
And so this is a draft of the final report that you're sending to Captain and Goose, correct?
I don't believe this is the draft of my final report, it was the draft at the time.
Correct. I misspoke. I'm sorry.
Yes,
It is
yes.
a draft of a proposed report,
Correct.
correct? And you're sending it on July 11th, correct?
Yes, sir.
8 days before Michael Proctor's interview.
Correct.
3 days after his duty status hearing.
Yes, sir.
And is it fair to say that as of July 11th, DLT, you're not finished with your investigation?
I'm not.
And you make the statement that it has not been peer reviewed yet. What does that mean?
Prior to us submitting a final report, when I read a report, it gets submitted to a peer for another set of eyes to look at it to see if anything was missed.
Okay? And you state, for the interest of time in being able to submit tomorrow. What did you mean by that?
I can't speak to that, probably for another review. At that time, I can't speak to what I meant by that. The invoice wasn't done yet, so I don't know why we will submit. I assume it was to submit it for a peer review.
Well, don't the words "for the interest of time" suggest that this was a priority?
This case was a priority.
And don't the words "for the interest of time" suggest that somebody might have told you, hurry this case along?
No, sir.
Okay, you just wrote those words.
I did, sir.
And so this document has 8 pages, correct? The draft report.
Yes, sir.
And on page 6, you have conclusions, correct?
I do.
So you had conclusions already drafted on page 6, 8 days before Michael Proctor was interviewed, correct?
As a draft, but I
got you.
believe,
Yeah.
if I could,
Yeah, go ahead.
I believe, I also, in somewhere in one of the emails, I specified that any conclusions that I drew was based on information that I knew at the time, and it was pending the results of Trooper Proctor's interview.
Okay. You said you wrote that somewhere?
I did.
Has that been produced to us? Not right now.
Courtesy.
But in any event, sir,
For the record, this was turned in,
Wait, hold on.
I apologize.
But I'm speaking, I'm the only one
I
speaking.
apologize.
All right, what did you just give to Mr. Moynihan?
A courtesy copy of an email he already has,
Is that,
of an email he already has that was produced in the same production that the department gave to counsel for the appellant as part of its full production prior to August 12th as ordered by the commission. This is a courtesy copy because I suspected Attorney Moynihan was going to go here and attempt to misrepresent the record. This is an attempt to correct the record.
can I see a copy, please?
May I approach?
Mr. Moynihan, would you admit this into the record?
Do you have time to read it?
I'm sorry?
Do you have time to read it?
I quickly just read it. There is an email. I don't have, I can move on.
Right, I'm just saying, do you want to submit it? You want
No,
to do that later?
I don't wish to submit it.
All right, thank you. I'll hold on to this for now.
Thank you.
Thank you. Please proceed.
DLT, I've asked you a number of questions, factual questions here this morning about this draft, correct?
Yes, sir.
Have I misrepresented anything to you?
Nope, nope.
Thank you. Now, on the draft, it's dated August 14th, correct?
Yes, sir.
What was the significance of August 14th?
So if I could, it's actually dated August 14th, 2025,
Yeah, right,
which would have been about 2 weeks ago.
okay.
I can only surmise, but this was probably a Word document. The Word documents I use auto-update the date field. So I assume that that was the date that this document was printed. That is not the date that I drafted that letter.
Okay. And was there any significance to August 14th of '24?
Not that I can recall, sir.
But in any event, you do have conclusions on page 6, right?
Correct.
And they take 3 pages.
They do.
Now, could you look at Exhibit 30, please?
Yes, sir.
And we have on APP 0150, an email from you again, correct?
Yes, sir.
And that's from you, correct?
It is?
To Suzanne Caravaggio,
Yes, yes,
the
it is.
department prosecutor, right?
Yes.
And also copied to Bruce O'Rourke, the captain.
Yes.
And the date of this is Friday, July 12, 2024, 10:33 a.m., Friday morning,
Correct.
same day. And you say to Suzanne, attached is the draft report for IAS 240014 for your review. Thank you, Kevin, correct?
Yes, sir.
And correct me if I'm wrong, I think you told us you were not aware that Suzanne was trying to schedule the trial board already on that day.
Correct.
And this is 8 pages, correct?
It is?
And again, you have conclusions already made, correct?
I do?
And why are you sending it to Suzanne?
It's normal process to have multiple people look at a report to, again, find any missing elements or something that needs to be addressed.
Is it normal process to send her a draft of a report before the subject's been interviewed?
It's not unnormal or abnormal.
How many times have you done that?
I can't put a number on it, sir, but I'm sure I've done it multiple times.
When was the last time you did it?
I couldn't speak to that, sir.
Michael Proctor's case?
It could have been.
Could you go to 31, please, which is APP 00160?
I'm there, sir.
All right, and so we have here an email from Suzanne Caravaggio, correct?
Yes, sir.
To you,
Yep. Yes, sir.
subject Proctor.
Correct.
Date, Friday, again, it was a busy day, wasn't it?
A lot of emails, sure.
Friday, July 12th, 2024 at 12:46 PM, correct?
Correct.
And the attachment is Proctor, case number, report, ... correct?
Yes, sir.
And Suzanne says to you, Kevin, please see the attached draft report with edits. Thanks, Suzanne, correct?
Yes, sir.
Now, the first thing I have to ask you about is, on the first page of this, now the report's 9 pages, correct?
Yes, it is.
And again, this is 7 days before Michael Proctor's interview, correct?
Yes.
And so, on the first page of the report, with edits, the date is changed by somebody, correct?
Again, I believe that's the auto update feature, because it's again changed to August 14th, 2025.
Okay. Do you know what date originally was on these documents?
It appears it was July 12th, 2024.
And so, in any event, she makes additional edits to the report, correct?
She does.
And it now becomes 9 pages.
Correct.
And this is a week before Michael's interview, correct?
Correct. I believe it went to 9 pages though, because when Suzanne looks at it, she uses what's called track changes.
Yeah.
So the bulk of her edits have to do with grammar or spacing. So when you make the track changes, it doesn't take out what was originally written. It just puts her recommendations in there. So that's why it makes the document longer.
Could you go to Exhibit 32, please, sir? Appellant's Exhibit, which is APP 0171.
Yes, sir, I'm there.
All right, so this is another email from Suzanne Caravaggio, correct?
It is.
To Kevin Dwyer, correct?
Yes, sir.
And its subject is Proctor, draft charge outline, correct?
It is.
And the date of it is Friday, July 12th, 24, again, correct?
Correct.
12:49 PM.
Correct.
3 minutes after she sent you her draft report with edits, correct?
I believe that's accurate, yes.
And this is 4 days after the duty status hearing where Michael was suspended without pay, correct?
Correct.
And it was 7 days before the interview.
Correct.
And she's sending you a charge outline, correct?
For potential charges, yes.
So is it fair to say that Suzanne Caravaggio is advising you of what charges you need to find Michael Proctor guilty of?
That is not accurate.
Well, what is the purpose of this?
To advise me of what the potential charges are. I think that is unfair to say that anyone tells an investigator what charges to find guilt on.
Okay, well, I'm just reading a document.
Charges to what?
To find guilt on.
I'm just reading a document, sir, and I'm trying to infer what it means, but you told us that you don't decide the charges and
I
how
do
the
not.
case plays out at the end, right?
I do not.
Well, would it be fair to say Suzanne does do that?
Suzanne's part of that process, yes.
So Suzanne's the person who decides what the charges should be?
She-
Objection. Has to be answered.
I believe Mr. Martin, I believe the witness did say she's part of it.
Thank you, he answered it. And so she then attaches an email, with her email, she has an attachment with potential charges, correct?
She does.
And she has 4 charges listed.
She
Correct.
does. Yes, sir.
and the first one is unsatisfactory performance.
It is.
And that's ultimately what Michael was charged with, correct?
Yes, sir.
And that's ultimately what Michael Proctor was fired for, correct?
I can't speak to that, sir.
You don't know that today?
I don't know what caused that, the determination for
No.
discipline.
My question,
I'm
sir,
sorry,
is,
hold on one second.
sorry.
His voice is dropping and you're asking the
Apologize.
question. So what I have so far is I don't know what caused the termination for the,
I don't know what played into the process to cause the termination, as far as what weight was placed on which charge.
Okay. But you know that, as we sit here today, that Michael Proctor was fired for unsatisfactory performance, Class A, correct?
Correct.
And that's one of the charges Suzanne Caravaggio suggests to you.
It is.
And then she has dissemination, alcoholic beverages, and use of equipment, correct?
Correct.
Now, use of equipment is a Class C violation, correct?
Yes, sir.
Madam Commissioner, could I have 1 second?
Of
Just to.
course.
If I could just have a moment. Madam. DLT, could you go to Respondent's Exhibit 26, please?
Okay, this is allowed to move.
Yeah, that's, thank you.
26, you said?
26. It would be R0667.
I'm there, sir.
I'm sorry, can you repeat?
R0667.
Please go ahead.
Okay, thank you. You ready, sir?
I am, sir.
All right. So let's go, first of all, let's work from the bottom up. Use of equipment is a Class C violation, correct?
Correct.
And looking at page 1 of 5, R0667, Class C violations for a First Amendment offense, you can't be fired for that, right?
For the first offense, no, you cannot.
Okay. Looking up alcoholic beverages and drugs, which we'll talk about later, that's a Class B offense, correct?
It is.
First offense, Class B, you can't be fired for that, right?
Correct.
Dissemination of information, Class C. First offense, Class C, you can't be fired for that, right?
Correct.
Unsatisfactory performance, if you could turn to page R0669 of this index of rules and regulations. Actually, let me back up, sir, just so we know. What are we looking at here?
This is the Appendix A, it's the discipline guidelines.
Discipline guidelines for the Department of State Police.
Correct.
And this is the, essentially the rule book for disciplinary offenses and what the department can do in terms of the finding of a guilt on a disciplinary charge, correct?
Correct.
All right. And they're regulated by these guidelines.
They are.
And so looking at page R0669, tell me when you're there.
I'm there.
Okay. And so Suzanne recommends 5.82, unsatisfactory performance, Class A, correct?
Yes, sir.
And so looking on page 3 of 5, R0669, do you see 5.8.2 in the middle of the page under unsatisfactory performance?
I do.
And is it fair to say, sir, that the department can choose at its discretion to classify it as a Class D, which would not be fireable, correct?
Correct.
Class C, which would not be fireable, correct?
Correct.
Class B, which would not be fireable?
Correct.
Or Class A, which would make it fireable, correct?
Correct.
And so it was discretionary in this case to classify Michael Proctor's unsatisfactory performance charge as an A, B, C, or a D.
I don't think I can speak to that, sir.
Well, no, I'm just going by the guidelines.
Oh, well, yes, based on the guidelines, yes,
Right.
it is,
Right.
yes.
And Suzanne, in this email, is telling you unsatisfactory performance, Class A, correct?
Correct.
And Michael Proctor was never charged with dissemination, was he?
I don't believe so, sir.
Could you go to Appellant's Exhibit 33, please? Which is APP 00, I'm sorry, APP 0174.
Yes, sir.
Okay, now, this is an email from you, correct?
It is.
To Suzanne Caravaggio again.
Correct.
Subject Proctor draft charge outline, correct?
Correct.
And again, this is on that Friday afternoon, July 12th of 24 at 1:08 PM, correct?
Correct.
And your email to Suzanne is attached as the copy for you to continue reviewing. Thank you.
Correct.
And again, the date on the report is misstated again, correct?
It is.
And this is again an 8-page report, once again, correct?
It is.
And on page 6, we begin with a conclusion section, correct?
Correct.
And this is 7 days before Michael Proctor's interview.
6 days, yes, 7 days, correct.
Could you turn to Appellant's Exhibit 34, please? Which is APP 0184. Page number.
Yes, sir.
All right. This is another email from you to Suzanne Caravaggio, correct?
It is.
And she's the prosecutor for the legal department.
She is.
And again, subject Proctor-report, correct?
Correct.
This one's dated Tuesday, July 16, 2024 at 5:06 PM, correct?
Correct.
And it says, thanks Suzanne Kevin, correct?
Yes.
Now, apparently just prior to that, Suzanne had sent you an email on July 16th at 5:06 PM, correct? Does it appear that way?
Yes.
And it says, subject Proctor report, and it says, hi Kevin, attached please find your current draft of your report in Proctor with my changes. Please let me know if you have any questions. Thanks, Suzanne, correct?
Yes.
And the report is now 9 pages, correct?
Yes, sir.
And this is 3 days before Michael Proctor's interview.
Yes, sir.
Could you go to Exhibit 35, please? APP Bates number 0196.
Can you please repeat that?
Bates number APP 0196. You there, sir?
Yes, sir.
All right. And so, this is an email from you, correct,
It is.
to Jeremy Sweeney.
Correct.
Who's Jeremy Sweeney?
Jeremy Sweeney was the DLT that was an OPIA.
All right. And the date of this is Wednesday, July 17th, 2024 at 7:07 PM, correct?
Correct.
And the attachment is Proctor, case number, report draft, ... correct?
Correct.
And attached to this, sir, is a report of 12 pages, correct?
Correct.
A draft report of 12 pages.
Yes, sir.
So the report has now grown from 9 to 12, right?
Correct.
And this is 2 days before Michael Proctor's interview.
Yes, sir.
So at this point in time, July 16th, this report's been reviewed by Suzanne, by you, by Goose, and by Sweeney, right?
Correct, sir.
And Suzanne had suggested to you what the charges should be, correct?
She did not suggest to me what the charges should be.
Well, I guess, let me just, I don't want to misstate what she's doing there, but what is she doing there when she sends you that potential charge outline?
So I believe that's what the potential charges would be.
All right, so she's not suggesting that to you, is that what you're saying?
She's not suggesting to me as, in regards as to how my invest should move forward.
Okay, fair enough. Now, on page 6, if you could, of the report, which is APP 0203, could you please look at that?
Yes, sir.
So you added paragraphs 9 and 10, correct?
Yes, sir.
And in paragraph 10, you state, now this is dated July 16th, correct?
It is.
So in paragraph 10, you say, on July 19th, 2024, I, along with Detective Lieutenant Jeremy Sweeney, interviewed Trooper Proctor at General Headquarters, correct?
It does.
That didn't happen yet.
No, but if you notice, those two paragraphs are in bold.
Yeah,
So this is a draft copy of my report.
okay.
The way I do reports is I write the report as it goes. At the time that I wrote this, the interview was scheduled for July 19th.
Right.
So I pre-wrote this because that is a boilerplate paragraph. That is the same language that's used in every paragraph, but I put it in bold because it was subject to change.
But answer this question, sir. Had the interview happened yet?
It had not.
And you state that Trooper Proctor was accompanied by Sergeant Johnson and Spam Attorney Daniel Moynihan. We hadn't arrived yet, right?
Again,
Yes or no? Yes or no? With all due
No.
respect.
Nope, it has not.
And you say, that 4 lines down, this interview was digitally recorded with the consent of all persons present and later transcribed. That hadn't happened yet.
Objection.
Correct.
We've been through this. He says it's a form paragraph that is written. It's the same in every report he writes. He fills in the details, and then he corrects it after the fact if it needs it. But he has already testified that this is something he pre-filled before the interview took place because it's a boilerplate paragraph. This questioning is badgering and irrelevant and misleading.
I'll allow the question. Thank you, Mr. Carlin. Do you want Mr. Monahan to repeat that question?
Please.
Paragraph 10.
So it says this interview was digitally recorded with the consent of all persons present and later transcribed. Again, that hadn't happened yet,
It
correct?
did not happen yet, correct.
And then in paragraph 11, you say, in summary, Trooper Proctor stated the following with a colon, correct?
Correct.
And then it says, Trooper Proctor said, ... right?
Correct.
So in other words, you were gonna fill in the blanks.
That was a placeholder, so when I completed Trooper Proctor's interview, I could fill in what he told us, yes.
Is it still your testimony, sir, that nobody told you to rush this case through?
It is.
Is it fair to say that Michael Proctor's subject interview here was just a formality?
That is not true.
Is it fair to say that Michael Proctor's termination was just a predetermination?
I can't speak to that, sir.
Now, on page 10 of that report, can we look at that, please?
Yes, sir.
Now, you spent quite a bit of time with Attorney Carley going through your sustained findings, did you not?
I did.
And here, 3 days before Michael Proctor's interview, before your investigation is finished, you have made 12 recommendations, correct?
Correct.
And you've recommended whether to sustain or not sustain before the interview's done, before the investigation is done. Is that fair to say?
Again, this was a draft report, and I would point you to that email that I sent before, saying that these recommendations were only based on the information we knew at the time, and they were subject to change pending Trooper Proctor's interview.
Did any of these recommendations change?
I don't believe they did.
So, fair to say again, sir, that 3 days before the investigation let me strike that, 3 days before he gets interviewed, before your investigation, you've made 12 recommendations to sustain or not sustain, correct?
Based just on the information that we knew at the time, correct.
And it was these charges, were they not, that got presented to the trial board?
These recommendations?
Yes.
In the final draft, yes.
Yes. And it was these charges which served as the basis to fire Michael Proctor.
Yes, sir.
And in the regulation, Michael Proctor, as an employee of the Mass State Police, was entitled to all constitutional protections, correct?
Correct.
And doesn't that include due process?
It does.
Now, I want to ask you a series of questions about Michael Proctor's interview on July 19th.
Yes, sir.
So this interview took place on July 19th, 3 days after that last report we just looked at, right?
Yes, sir.
And I was there,
You were?
and there was another attorney there, correct?
Correct.
And you were there, and then Mr. DLT Sweeney was there, right?
Correct.
Right. And is it fair to say, as of that date and even up until the present, you've never seen the entirety of these text message threads?
Can you ask that again?
Two questions, I'm sorry. So, let me say it up to today's date. Have you ever seen the entirety of these text message threads, hundreds of thousands?
I have
of
not,
texts?
no.
Okay. We only have these clips, correct?
Correct.
And that's what we went with on July 19th?
It is.
So, it's fair to say that there are 4 groups of text messages, and I'll go through them, just part of my question. There's a text message with friends that he grew up with, right?
Correct.
And you're aware that those guys all grew up in Canton?
Yes.
And then there's text, and I think we discussed this, there are 38,707 total texts between him and his friends over a period of time, correct?
That number sounds accurate, yes.
And we don't have all those.
No, sir.
And then the text with his sister, correct?
Correct.
And there were 2,865 total texts between him and his sister, correct?
Sounds to be right, yes.
And then there were texts with his wife Elizabeth, correct?
Yes.
And these are private texts, right?
Yes, sir.
And there's such a thing known as a spousal privilege in the law, isn't there?
Yes, sir.
And Michael never asserted that privilege, did he?
He did not.
And there are 1,162 texts between he and his wife, correct?
I don't know the number, but that wouldn't
Sound about
surprise
right?
me. Yes, sir.
Okay, but we didn't have all those.
We did not.
And then the text with other troopers in the unit. There were 43,380 texts between he and the other troopers in the unit, correct?
Again, sounds about right, yes.
Okay. By the way, was any other, and these all happened back in 22, the text with the other troopers?
Yes, sir.
No other trooper faced discipline as being part of these conversations, did they?
I don't know if I can speak to that, sir. I wasn't involved in any other processes.
Okay, fair enough. Did Michael Proctor ever deny the authenticity of these texts
He did not.
in his interview,
He did not.
at the trial?
He did not.
Did you ever find him to be untruthful in any way
I did not.
with respect to the text, with respect to his investigation?
I did not.
And is it fair to say that Michael Proctor has repeatedly apologized for these texts?
He has?
And he's told you and others, many, many others, that they were unprofessional and regrettable and juvenile, correct?
He did.
Now, you served as a detective in a DA's office, correct?
I have.
That was in Worcester County?
Yes, sir.
And you were there for 6 years, right?
Approximately, yes.
Okay. And you're familiar with the protocols of a DA's office and detective units?
I am.
And so there have been terms used here, lead investigator and case officer, correct?
Yes, sir.
Are those the same thing?
Essentially, yes.
Okay. And so in the Reed case, Michael Proctor was assigned by his bosses to be the case officer.
Correct.
Is it fair to say that a case officer is kind of like a secretary for the case?
I don't know if I would use the term secretary. My understanding of case officer, while they're the person responsible for the complete investigation, they're not necessarily the one that does all the work. They do a bulk of the work, and then they ensure that everyone else who's assigned different tasks in that invest do what they need to do.
And it's the case officer's responsibility to collect everyone else's reports, correct?
Correct.
And there are many people who work in an investigation on a homicide, correct?
There are.
And so, as case officer, it doesn't mean Michael Proctor's in charge of the unit, does he?
It does not.
And he's kind of like a spoke in the wheel, right?
Yes, sir.
Okay. And so, by coining Michael Proctor as the lead investigator in the Reed case, it suggests that he was in charge of the investigation, does it not?
I think the argument could be made that, I don't know if in charge is the right term, but he's the one that's responsible for the investigation.
Okay, but he still has to answer to Sergeant Buchanan, right?
Correct.
And DLT Tully,
Correct.
and Lieutenant Fanning,
Correct.
and Captain Collins,
Correct.
and Major Copenrath,
Correct.
and Lieutenant Colonel Connors,
Correct.
and ultimately Colonel Mon and Deputy Pinkham, correct?
Yes, sir.
And so, he's at the bottom of the run.
In that chain of command, yes, he is.
So he does, and as a trooper, you're obligated to follow the orders of your superiors, correct?
Yes, sir.
So is it fair to say that in a homicide investigation, which you're familiar with, right?
I am.
It is a collaboration between all members of the DA's, of the SPDU unit.
It is.
And it's also a collaboration between the State Police SPDU unit and the DA's office.
It is.
And Michael Proctor did not have authority to supervise this investigation in the Reed case, did he?
As a supervisor, no.
And he did not have authority to decide what to charge Miss Reed, did he?
Correct.
And he did not have authority of whether to charge her, correct?
Correct.
That's the decision of the Norfolk County DA's office.
It is, yes.
And so, could we go to Respondents Exhibit 20, please?
You said 20?
Yes, please. And it is base number RO 513, 514.
You have a page number, sir?
Yes, as RO 514 is where it starts, and I just need to get my bearings to go to the specific page. And I'm going to go to base number RO 521.
I'm there, sir.
All right. And so this is Exhibit AAA in the Reed case, correct?
Correct.
Dated 6/12/24.
Yes.
And going through this, first of all, this is the text message chain with his friends who grew up in Canton, correct?
Yes, sir.
Now, when conducting an investigation in a homicide, is it fair to say that as an investigator, you form opinions about the case after a certain amount of investigation has been conducted?
Yes, sir.
And is it fair to say that you form opinions as a human being about the suspect based on fact and reason?
Yes, sir.
And it's natural, it's human nature, is it not, to form an opinion about someone you believe to be the suspect of a homicide?
Yes, sir.
Okay, but it should be based on fact and reason.
Correct.
And you have conducted, I think you told us previously that after you conducted an investigation, you formed opinions about suspects, correct?
I'm sure I have, sir, yes.
You don't have warm, fuzzy feelings for somebody you think committed a homicide, correct?
I probably wouldn't know, and I have not, yes.
And you said in your report it's entirely reasonable for some investigator to form an opinion about a suspect.
Yes, sir.
And it's entirely reasonable to express your personal opinions to family members and close friends, correct?
It is, but as a police officer, there are certain things that you cannot share.
Okay. And the statements that we're going to look at here, I'm not going to go into detail on, but these were made in a private setting, correct?
Yes, sir.
And you would agree that you and me and everyone has an expectation of privacy on your personal cell phone, correct?
As a citizen, but as police officers, we have a different expectation.
Okay, but we did say earlier, did we not, yesterday, that there's no state police policy governing personal conversations on a personal cell phone, correct?
There is not.
Objection.
What's the objection, Mr. Collins?
That's misleading and it's mischaracterizing the testimony.
What was your recollection?
My recollection is that there was no specific policy violation suggested with regard to Detective Lieutenant Dwyer's investigation, but it is not the same thing as there is no policy that governs the conduct of an investigator like Michael Proctor with regard to their behavior using a personal cell phone. That is not the same thing.
I agree with Mr. Collins and Mr. Martin, it's not the same thing.
I didn't ask about conduct, I asked about personal content of conversations on a personal phone, and we've discussed the fact there is no policy. If DLT Dwyer can go through the 1,000 pages of policy and find it, then let's go do it.
I'd be happy to point him at the charges with which Michael Proctor was brought up and convicted.
I understand, but he's saying that it isn't a state police policy.
Correct, that's my question.
No, I'm just saying, what do you have in regards that would be close to that?
I'm sorry.
The policy, there's a policy of a state police work phones, isn't there?
Yes.
What?
Well, no. So let me clarify.
Okay.
So I don't want to testify, but what I'm suggesting as a representative of the department is that the rules governing the conduct of members apply at all times, including Article 5. They do not differentiate between personal cell phones, work cell phones, or any cell phones. They simply apply at all times to all members. And it's possible, without reference to a phone, as Michael Proctor did, to violate those policies by means of a phone. But it doesn't matter whether it occurs via email or smoke signal or personal cell phone. It doesn't matter. Those policies equally apply to all behavior of the member as members of the Massachusetts State Police. So it's misleading and it's argumentative to suggest that just because a specific policy was not written for this member's misconduct, that therefore no such policy applies to him. That's simply false.
I'll accept Mr. Carley's explanation and his objection.
May I follow with a question that's very, very specific and not like the discussion that Attorney Carley just presented. It concerns only whether there exists a policy concerning personal content on a personal phone in a private conversation. Is there or is there not a policy? And we talked yesterday, there is not a policy, I'm just
today.
confirming.
Do you have an objection to that question, Mr. Carley?
I don't have an objection to the question being posed, but the premise under it is
I understand.
is flawed.
I understand. Mr. Dwyer, do you want him to repeat the question for you?
Please.
Thank you.
We have probably 1,000 pages of policy and regulations, correct?
Correct.
Is there a policy or regulation prohibiting the way that you speak to friends and family on your personal cell phone?
There is not.
Thank you. So could we look at Bates RO 521, please?
Yes, sir.
Can you please repeat that, Mr. Martin?
I'm sorry, Bates RO 521. And so, are you with me, Lieutenant?
I am.
DLT. And so the first text is late in the evening on January 29th of 22, correct?
Yes, sir.
And it comes from somebody named Bird, right?
It does.
And we learned from the video we watched yesterday that Bird's one of these guys from Canton's nickname, right?
Correct.
And he's also known as 1311, who's it's the last four of his cell, I suppose.
Yes, sir.
And then we have, just so I'll go through it now, we have 1311, we have 5051, correct?
Yes, sir.
Is that another person's cell phone, the last four numbers?
I would assume
All
yes.
right, and then following on the page, we have more from 5051, and then we have down the bottom of page RO 522-0095. You see that?
Yes, sir.
And so it appears from this initial text thread that there are three people on this, correct?
It would appear that way, yes.
And there's Michael Proctor and then three people, three buddies from Canton.
Yes.
And so the first text is late in the evening on January 29th at 10:36 PM, correct?
Could we back up? I just don't want to be, so it does appear that there's three phone numbers there. It also appears in the gray, there's a fourth person. I assume that's Trooper Proctor.
Yes,
So
right, that's what I
so
said,
it'd be
Trooper
four.
Proctor
Okay,
plus
okay.
three buddies from Canton.
I apologize.
And so, and you may not know this, but I think I asked you, are you aware that Michael Proctor was assigned to this case in the early AM hours, around 6 AM on the 29th of January 22?
I don't know when he was assigned as a case officer.
You're familiar with the fact that there had been work all day long, 16 hours plus on the investigation, correct?
So I don't know when the invest started, but yes, I would assume that there was a full day's work put into this.
And you're familiar with the fact that Trooper Proctor had been with Sergeant Buchanan pretty much all day conducting investigation?
I am unaware of that.
All right. It's fair to say that there would have been many units of the state police, Canton police, all doing an investigation, correct?
Again, I wasn't there, but I would assume that there were multiple assets there.
And based on your experience in the DA's office, Worcester County, fair to say that when there's a homicide early in the morning, there's a debriefing at the conclusion of the day?
Sometimes there is, yes.
Okay. And are you aware of the fact that at 10:36 at night, that night, Michael Proctor was at home?
I am unaware of that.
Okay, fair enough. Could we look at Exhibit 48, please? Appellant's exhibit, and I'll have the Bates number in a second, Madam Commissioner. It's Bates number 0297.
Yes, sir.
You there?
I am.
All right. And we have here a Canton Police report, correct?
Yes, sir.
And you told us in the previous hearing that you don't know who was there at the scene. You don't know how many people were there, because you
I don't.
didn't go there, right?
Correct.
You aware of the fact that Michael Proctor didn't go there either that day?
Can you?
Are you aware of the fact that Michael Proctor did
I am
not
not
go
aware
to
of
the
that,
scene?
no.
And this Canton Police report is dated January 29th of 22, correct?
Correct.
And right at the top, it says it's done by Sergeant Sean Good,
Yes.
and it says above his name, January 29th, January 29th, 2022 at 8:24 in the morning, correct?
For the report date, correct.
Right. So Sergeant Good has completed his report as early as 8:24 in the morning, correct?
I'm sorry, objection. Can we go to sidebar, please?
Please.
I thought this was public. I'll ask first, sir, you're experienced as a homicide investigator, correct?
Ask it again?
You're an experienced, the answer is yes, I think. You're an experienced homicide investigator.
Yes, sir.
And so when there's a homicide, it's necessary for a lot of state police units to appear at the homicide scene, correct?
Usually, yes.
Who are those units that show up?
It could be anyone from the SPDU to crime scene services. If a firearm's involved, ballistics, the crime lab, it could be a number of units, sir.
And so, is it reasonable, is it also fair to say that the local police show up at the homicide scene?
Yes,
And there would be EMTs there,
there could be, yes.
possibly, and fire departments possibly?
Again, possibly, yes.
And so in this particular case, we're talking about Karen Reed, is it fair to say that all those units were probably there at the scene that morning?
A lot. You can answer this, Dwight.
So I would assume,
Based on your experience,
I would assume a number of those assets may have been there, yes.
okay? And could you look at Appellant's Exhibit 48, please?
Yes, sir.
It's APP 297. This is a report from the Canton PD, correct?
Correct.
And on page 2, there are persons listed, correct?
There are.
And there are how many people listed as persons being present?
On this page, there are 7.
And then 3 on the following page?
Yes.
Total of 10 persons present at the
Cor-
scene?
Correct.
And are you familiar with Canton?
I am not.
All right. Familiar with the fact it's a small town?
I know nothing about Canton.
Good, okay. Back to Respondent's Exhibit 20, sir, RO 521.
Yes, sir.
Now, again, Trooper Proctor, Michael Proctor was not charged with dissemination of information, correct?
Correct.
And so looking at that first entry, these are all, again, just don't want to repeat, but January 29th, 10:36 is the first text message, correct?
Correct.
And it's from Bird, and it says, as we heard in the video, I need to brandish a gun more often, correct?
Yes. Yes.
And then somebody 5051 at 10:37, a minute later, says it's bold,
Correct.
correct? Now, did you ever interview any of these friends from Canton to find out what they knew and what they didn't know?
I did not.
Is there a reason for that?
It was irrelevant to my invest.
How do you know, how would you know what they knew already before Michael Proctor texted them?
Again, that was irrelevant.
Oh, okay. All right. So you don't know who 5051 is,
I do not.
and you don't know who Bird is,
I do not.
and that wasn't relevant to you.
No, the focus of my investigation wasn't that Trooper Proctor was advising people or teaching people about information. It was the fact that the information he shared, he should not have shared.
Okay. And so at the bottom of page 0521, 5051, who we don't know who it is, correct?
Correct.
Says, and by the way, I guess Mike's nickname is Chip, correct?
Yes.
So 5051 at 10:52 on January 29th says Chip, name of that BPD cop, correct?
Correct.
And prior to that, there had been no transmissions from Michael Proctor, correct?
It does not appear to be, yes.
Do you know how this guy, 5051, already knew that the decedent was a BPD cop?
I do not.
Is it not clear that this guy already knew that the victim was a BPD cop?
It appears that he knew, yes.
And based on the text, that information did not come from Michael Proctor,
I don't know where that information came from, sir.
but not from Michael Proctor on this text chain.
From what I see in front of me, no.
Right. And you never spoke to 5051?
I did not.
And is it fair to infer, sir, that people in Canton, as well as the Boston Police Department, would have known during the day of January 29th of John O'Keefe's death?
Objection.
Okay, Mr. Conlon?
People would have known. I don't even know what counsel's asking. It's completely vague and inappropriate.
Cross-examination.
Can you raise a question?
Fair to
Mr.
say,
Conlon?
huh? Officer O'Keefe's body was found early in the morning of the 29th of January, correct?
Correct.
And he was a Boston cop.
He was.
Boston Police Department would have known about this during the day, correct?
I would assume they would, yes.
And people in Canton would have known about it at some point. Various people in Canton would have known about this during the day, correct?
I would assume yes.
And during Michael Proctor's interview, he told you that many of his comments about waffling and various things were opinions of his, correct?
Correct.
And it's fair to say that as a homicide investigator, and again with human nature, you formed opinions about a case after conducting a full day of investigation, correct?
You would.
And fair to say Michael Proctor did not share any investigative strategy in his text messages, did he?
Yes, he did.
All right, well, let's look at your prior testimony. You recall testifying in a trial board in this matter?
I do.
Would you go to exhibit 20, respondent's exhibit 28B?
Do you have a page number, sir?
Just give me a moment. Page 159, line 11.
I'm sorry.
Page 150, RO 969, page number.
Give me a second, sir. $969, you said?
Yes.
I'm there.
So let's start at the top. Question, when Mike Proctor was interviewed by you, he told you that many of those comments you made were opinions, correct? And your answer was correct, right?
Correct.
Going down to line 11. But he didn't share any investigative strategy was the question, and your answer was not that I'm aware of, correct?
No, that's not what I said.
I'm reading that incorrectly?
You are.
How so?
If I could read.
Those two lines?
Yes, sir. You're talking about line 5?
No, I'm talking about line 11.
All right, I was looking at line 5.
No, I'm looking at line 11. Question is, he didn't share any investigative strategy, and your answer is not that I'm aware of.
Objection. Doctrine of verbal completeness. The witness has just directed counsel's attention to line 5, where that question was asked the first time, and the witness's answer, if I may read from this page, lines starting on line 7, answer, well, so he did send a text saying that he was going to place Miss Reed under arrest. It's completely inappropriate for counsel to then point to line 11 and then suggest that the witness's answer in lines 7 and 8 never occurred.
You know, Ms. McConaughey, I know it's uncomfortable sometimes to hear the other side of the story, but I asked him to look at line 11. not line
He did
5.
ask him to
He
look
can
at line
redirect
11
the
only.
witness
That's
when he
true.
chooses
Okay, hold
to.
on one at a time.
Okay, so I'm gonna ask you guys again.
Line 11.
We're making recordings, we have a stenographer. It makes your job difficult if
I
one
understand.
person is speaking.
I'm just
It
trying
makes my
to,
job difficult because I'm gonna listen to you in real time. All right, so when there's an objection, you finish your question, there's an objection, the person has the floor, then you can speak again. But I can't keep reminding people to stop speaking over each other. Okay.
okay,
Did you
just-
get all that? Did you get
Well,
any questions?
I'm off the record for a second. When there's crosstalk, I can't. So I go with the leading person at the time,
Yeah.
who's dashes, so crosstalk is really an issue.
Okay, so do you, how far do you want us to go back?
No, I mean, the record is what it is, but you said then you can speak again, but I can't keep reminding people, Mr. Moynihan understood. The new commissioner stopped speaking over each other, so if we could pick it up from there, but,
Okay.
thank you.
Perfect, all right. So, Mr. Moynihan, Mr. Carley's made the point that if you look at the page, and I understand that you're directing Mr. Dwyer to, line 11, but there is preceding, information. Mr. Carley, I'll leave that to you to do later in your redirect, but I'll allow Mr. Moynihan to continue, but again, please don't talk over each other.
Could the commission take notice of the doctrine of verbal completeness, that it's inappropriate for counsel to select and cherry pick lines out of this witness's prior testimony and to suggest that he answered something he did not answer?
I understand all that, but we can revisit that in your redirect.
That's fine.
Okay. Please go
so,
ahead, Mr. Moynihan.
so let's be verbally complete here, I guess, so if Mr. Carley is satisfied. Line 5, I asked, he didn't share with anyone investigative strategy, and you said, well, so he did send a text saying that he was going to place Ms. Reed in a arrest, correct? Is that what you're referring to, DLT?
Yes,
Just so
yes,
we're
sir.
clear.
Yes, sir.
I don't want to be accused of misrepresenting anything by Mr. Carley. And then I said, but that was after the indictment, and you said, correct.
Correct.
So that was after she was indicted already,
Correct.
by a grand jury.
Correct.
And the next question, which I was originally asking you about, was line 11. But he didn't share any investigative strategy, and your answer was what?
Not that I'm aware of.
Okay. And the next question I asked was, he didn't share any specific collection of evidence, correct? And what was your answer?
Not that I'm aware of, no.
And the next question was, he didn't share any specific statements by suspects, did he? And what was your answer? You said, I believe he did to a text, I believe to his sister, correct?
Correct.
Okay, fair enough. And the next question down the bottom, line 23, he didn't share any specific damage to Miss Reed's vehicle, did he? Your answer was what?
No, I don't believe he did.
And the next question was, he didn't share any statements or opinions of any other investigators in the unit, did he? And what was your answer?
No, he did not.
Could we go to your report, DLT Exhibit 18, and I'll get the base number in a second. It's base R490, again, beginning of the report.
Yes, sir.
All right, could we turn to paragraph 21, which is page 10 of your report, and it's date stamp R5, I think it's 500. I could be correct.
21 starts on 499.
Paragraph, oh, I'm sorry, you're right. 21 starts on 499.
I'm there.
Okay. If I could just have a moment. Okay, it's actually on the following page, sir, 500, you know, in paragraph 21. Fourteen lines down. Where it says that there is no evidence to show.
Yes, sir.
You see that?
I do.
So you concluded, did you not, that there was no evidence to show that Michael Proctor's personal feelings influenced his actual investigation in the case, correct?
Correct.
And if you could go to paragraph 30, which is page R0503, I believe.
Yes, sir.
And you stated in your report after your investigation that there was no evidence to show that the police actions taken by Michael Proctor were directly influenced by his personal feelings about Karen Reed, correct?
Correct.
And then up in paragraph 29, sorry to jump around. You stated in there, it's about 5 lines from the bottom of paragraph 29, that there was nothing learned in this investigation that showed that Michael Proctor acted with intent to affect the outcome of the investigation, correct?
Correct.
And so you had testified previously, and I'll get the transcript if we need, that the integrity of Michael Proctor's investigation was not compromised by his personal feelings, correct?
Again, nothing in my investigation showed that it was,
Right.
but my investigation did not focus on the facts of the criminal invest.
Okay, but you did make that statement and
I
you
did.
made that conclusion,
I
correct?
did.
And you told us that his performance, in your opinion, was above grade, correct?
I said from what I found, there was nothing to suggest that it was not.
And do you recall telling us also that his personal cell phone text did not affect the performance of his duties in this case?
Again, nothing found suggested that it did.
And you told us also that there was, based on your investigation, there was no evidence of bias in this investigation,
Correct.
correct?
Correct.
And paragraph 23, you also looked into this business about the allegation of a gift. You recall that?
I did.
And I think you addressed that in paragraph 23, and you testified about it previously. And you concluded that there was nothing learned through this investigation that suggests that Super Proctor or his wife ever had communications with a potential witness about a gift, correct?
Correct.
And you concluded that that statement was made as a joke,
Correct.
jest. And you concluded that Michael Proctor clarified that he had no intent for Karen Reed to kill herself, correct?
Correct.
And you did tell us also that not every text can be taken literally, correct?
With the family member, absolutely.
And this business about nudes, that was much to-do made by Alan Jackson, you looked into that as well, correct?
About the nudes, yes, sir.
Yeah. And Michael Proctor admitted that he had regret about that juvenile comment, right?
He did.
And he told you it was unprofessional and inappropriate, correct?
He did.
But you also told us that it is common when searching, strike that, first of all, Michael Proctor was looking at Karen's Reed photo because she was a criminal suspect, correct?
Correct.
And he had a search warrant for that.
That's what I believe, yes.
So he was entitled to search her phone pursuant to a court-ordered search warrant.
Correct.
And his purpose in looking through the phone wasn't to look for nude photos, was it?
It was my understanding that he was looking for, I believe, geographical data, any text pertinent to his invest, things along those lines.
And so, in your experience, I think you told us yesterday, it's very common when searching a suspect's phone that in this day and age, people take selfies and pictures of others in a nude fashion, correct?
It is not uncommon.
And so, it could be a joke that guys in the unit are joking around about it, correct?
Correct.
And you concluded that this comment about no nudes was a joke, in fact, correct?
So I found his explanation reasonable in that aspect, yes.
And you concluded that he was not looking for news, he was looking for incriminating evidence, data, location data, correct?
Again, there was nothing found that suggests that he actually did look for any photos.
And there was never any allegation in your investigation that Trooper Proctor planted evidence, is there?
No,
Or that he compromised any evidence, correct?
no.
And so, as a case officer, is it fair to say that one of his duties is to collect evidence
Yes.
and to analyze evidence?
Yes, to the extent that a case officer can, yes.
Right, because some things have to be done by a lab or some specialist, correct?
Correct.
And it may be his duty to draft and execute search warrants, correct?
Correct.
And it may be his duty to communicate with the labs who are doing testing, correct?
Yes.
And it may be his duty to respond to requests from the DA's office, correct?
Yes.
And it may be his duty to prepare and testify for a grand jury, correct?
Yes.
And it may be his duty to prepare for testimony at a trial, correct?
It would be, yes.
And it may be his duty to coordinate with other agencies in conjunction and collaboration on the investigation, correct?
Correct.
Mr. Moynihan, I'm sorry to interrupt you, but we do need to call a recess at 11.
All right, is that?
Yes, so this week, please.
Oh, sure, yeah.
I'm sorry, they put it on me earlier.
Yeah.
Thank you. 15 minutes?
Sure,
Would be
thank
good.
you.
back on the record, the time is now 11:24 a.m. And I am joined by Jason Walker, who was one of our summer clerks. He's starting his second year at the U of A school right now. So welcome, Jason. And we give great internships here at the Civil Service Commission. We'll do that.
Pastor Walker?
Thank you for your patience. As you know, technical difficulties happen in real life. So we're going to go back on the record. So again, the time is 11:27 a.m. and Mr. Moynihan is continuing his cross of Detective Lieutenant Dwyer. Thank you.
Thank you, Commissioner Cronin. Good morning again, DLT.
Sir?
So we just went through all of the duties of a case officer, correct?
Correct.
And in other words, all the duties of a case officer, all the duties that Michael Proctor would have had as a case officer, correct?
Correct.
And is it fair to say, sir, that you testified, and it's true that there's no evidence that Michael Proctor failed to properly perform any of those duties we specified, is there?
No, there is not.
And his duties, in this case, were to collaborate with others to identify the cause of John O'Keefe's death, correct?
That would be one of the duties, yes.
And this IA investigation, I call it IA, Internal Affairs Investigation, is solely about personal cell phone messages, correct?
Correct.
And many of them were while off duty, correct?
Correct.
And his personal cell phone messages had no relevance to his duties as a case officer, correct?
I wouldn't agree with that. I would agree that there was nothing shown that his duties were affected, but as a police officer, I think all of your behavior is relevant to your
All right.
duties.
Could you look at Appellant's Exhibit 28? And it would be RO 977 paid stamp.
What was the stamp, sir?
The base stamp?
Yes, sir.
RO 977.
The appellants or the respondents?
Respondents. 28.
Did you say it?
Oh, I'm sorry. Respondents. 28.
One more time with the debate stamp, sir, sorry.
977.
Okay, sir.
So, looking at line 13, question there, right?
Yes.
Question was, so these personal cell phone messages had no relevance to what we just went through all of his duties as the case officer. That was my question to you, correct?
Correct.
What was your answer?
Correct.
So you agreed with me on that.
Yes, and what I said previously is that while the text messages weren't his duties, they affect everything that he does.
But in this case, he's charged with unsatisfactory performance of duties, correct?
Correct.
And so is it fair to say then, DLT, that his personal cell phone messages did not affect his ability to perform his functions as a case officer?
There's nothing to find to suggest that it would.
And the actual steps he took as an investigator were based on fact and reason as far as your investigation, correct?
So I can't speak about the steps that he took as an investigator.
Okay, but you found no evidence to suggest that the steps he took as an investigator were not based on fact and reason, did you?
Correct.
And the Norfolk County DA's office did present this to a grand jury, correct? The Karen Reed
Yes, sir.
case? And Karen Reed was indicted by a grand jury, correct?
She was.
And as a matter of fact, the DA's office prosecuted Karen Reed, correct?
They did.
Not the decision of Michael Proctor by any means, correct?
No, it's not.
Could we look at Respondent's Exhibit 24, please? It is RO 643, page stamp.
Yes, sir.
May I proceed, Madam Commissioner? And so this is, what is this we're looking at?
Article 5, the rules of conduct.
Okay. And could we go to page 3, page RO 645, page stamp.
Yes, sir.
All right, and so 5.8 is titled unsatisfactory performance, correct?
It is.
And if we turn to the following page, we see 5.8.2, correct?
Yes.
And that's the charge that Michael Proctor was fired for, correct? 5.8.2?
One of them, yes.
Well, that's the only one he's fired for.
Okay, yes,
correct?
correct.
Because the other one is a Class B.
Correct.
And so 5.8.2, we've already demonstrated that that can be classified by the department at the discretion of the department as A, B, C, or D.
Yes, sir.
And here it's an A.
Yes, sir.
And so looking at 5.2, there are a couple of components to that section, are there not?
There are.
And so the first one is, it says unsatisfactory performance may be demonstrated by, first, a lack of knowledge of the application of laws required to be enforced, correct?
Yes.
Was there any evidence of that on Michael Proctor's part in this case?
There was none.
The second part is an unwillingness or inability to perform assigned tasks. Was there any evidence of that on the part of Michael Proctor?
There were not.
The third part is the failure to conform to work standards established for the member's rank, title, and position. Now, you just told us that Michael Proctor did not derogate from any of his duties, correct?
From his DA duties, correct.
Correct. And there's no evidence that he derogated from any of his duties as a investigating officer, correct?
Again, as it relates to his duties with the SPDU, correct.
Correct. His job
Correct.
as an investigator.
Correct.
And the next part of that is the failure to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention.
Correct.
And there was no evidence of that uncovered, correct?
Correct.
And
There's
then-
no evidence of that.
I'm sorry.
Is that correct?
There was no evidence of that, correct?
Yes.
Okay, thank you. And your answer, sir?
It was correct, yes.
I'll slow down.
I just missed the word, thank you.
And the fifth part of 5.8.2 is, states by an absent without leave, correct?
Correct.
And there was no evidence of that here, correct?
Correct.
But Mike Proctor was charged with unsatisfactory performance, Class A, 5.8.2, and that's what he was fired for.
Correct. Again, if I could just clarify, I found no evidence to suggest that any investigative steps or things that affected the case were affected affected by the text messages.
Okay.
Again, I didn't look at his duties as a trooper or as a member of the SPDU.
Yeah. And so, you didn't come up with the charges, we concluded that, right?
Correct.
And who's Captain Scott, do you know?
Captain Scott at the time was the assistant department prosecutor.
You can look at that while I ask. And DLT Dwyer, you uncovered no evidence of any unprofessional conduct on the part of Michael Proctor, other than on his personal cell phone, correct?
Correct.
And there was nothing except on his personal cell phone that affected his credibility, was there?
Nothing that I could find, correct.
And did you ever talk to Captain Scott about the appropriate charge in this case?
I did not.
Sorry, just have a moment. Could you go to Appellant's Exhibit 58, APP 0382?
And there, sir.
And so this is a to from, as you call it, correct?
It is.
Dated August 2nd of 24,
Correct.
and it's from Captain William T. Scott, Assistant Department Prosecutor, right?
Yes, it is.
And it's directed to 3 people, Suzanne Caravaggio, the Department Prosecutor, correct?
Yes.
Major Keith Agan, the Deputy Division Commander of the Division of Standards and Training, correct?
Yes.
And to Lieutenant Colonel Robert G. Shoemaker, Division Commander of the Division of Standards and Training, correct?
Yes.
And the subject is review of case number, Trooper Michael D. Proctor, correct?
Yes.
And Captain Scott, now is Captain Scott an attorney?
I don't believe so, no.
And so number 1 in his to from is, I have read and reviewed the material contained in case file IA 22414. Would that mean he read your report?
Yes, sir. I would assume that.
And he says, number 2, my recommendation for the appropriate charges is in this matter is attached, correct?
It does, yes.
And then Captain Scott identifies charge summary, charge 1, article 5.8, unsatisfactory performance, correct?
Yes.
And he labels them 3 specifications as class A,
Yes.
correct?
Yes.
And then charge 2, 510 alcoholic beverages labeled class B, correct?
Yes.
And so, was it I'm sorry, was it William Scott who was responsible for the decision of what to charge Michael Proctor with?
I would
Sorry,
agree.
Madam Commissioner, I have to object again. We covered this. The witness has now testified several times that he was not involved in that process and does not know, and that it is a process suggesting it involves multiple individuals. This question is now repetitive, and it's asked and answered.
I'll allow him to ask a question. Do you want him to repeat the question?
Please.
You looked at this document from Captain Scott, correct?
Yes.
Right.
After the investigation was over, correct?
That's it. I'm talking about today.
Yes.
So, was it Captain Scott who was responsible to decide what to charge Michael Proctor with?
Again, I wouldn't know that. I know there's a process that's involved, and there are multiple people that are involved.
Okay, fair enough. Respondents critical. Anyway, do I think? Just have a moment. Now, could you look at Respondents Exhibit 24, DLT, it's Respondents 24, date stamp 0643. We just looked at
Yes, sir.
it. And could you turn to,
Sorry, is that respondent 24? or-
Yes, respondent 240643. You have that in front of you, sir?
I do.
And so, Michael Proctor admitted to you the texts were unprofessional, immature, juvenile, poor choice of words, correct?
He did.
And that they were unbecoming,
He did.
and that they brought the department into disrepute.
I don't know if you use those words, but yes.
You used those words.
I did, yes.
And by the way, that term disrepute, that means the opinion of others has now been changed, correct?
Correct.
And you're familiar with 5.2 unbecoming conduct?
Yes, sir.
What is the genesis of that charge?
Objection.
What are you referring to with Mr. Cohen? Mr. Bryan, have you seen that Mr. Proctor, there was an unbecoming charge included?
No, my question to DLT, and I can lay more of a foundation.
Yes, please.
Sir, you're familiar with Article 5, correct?
I am.
And you've conducted investigations under 5.2 unbecoming conduct, I assume, correct?
I've never, so when I do an investigation, it's not under a specific rule or reg.
I get you, but as a department IA officer, it's incumbent upon you to be familiar with the rules, correct?
Yes, sir.
In Article 5 and Article 6 and so on,
Correct.
correct? And so you're familiar with the term, the Article 5.2 unbecoming conduct, are you not?
Yes.
Okay. And so what is the genesis of that charge?
I'm sorry, I still have to object. I don't know what counsel is asking. What is the genesis of it? Is he asking who wrote it? Is he
Oh,
asking where
I'll
it
read-
came from? What is he asking?
I'll read
One
it.
at a time, please. You finish, Mr. Cohen?
Yes, I'm honestly asking, I have no idea what that question is asking. Is he asking for the origin of the, genesis means the origin of something. What is he asking about 5.2? Who wrote it?
Mr. Monahan, do you want to finish your response?
I can do either of two things. First of all, I'm asking about his understanding of it.
Do you want to respond to what Mr. Carter just said?
Yes, I'm asking the DLT about his understanding of what unbecoming conduct, the basis of it is. And I can also read the article itself.
I think what I've heard is that the witness is saying when he's investigating, he has to conduct first, not the charge, and then sort of conduct. He goes by what the conduct is, and then examines the department's rules and regulations. Are you asking what unbecoming conduct is?
His understanding, based on his experience.
I'll allow him to answer the question.
I'm fine with that question.
Again, if he doesn't know, he doesn't know.
I mean, that was my question. It might have been
Sir,
improperly worded.
There's a process. I'm allowing you to ask the question.
So you asked me what my understanding of 5.2 is?
Yeah.
Generally speaking, it says that the behavior of a member, whether on duty or off duty, should reflect favorably upon the department.
Okay. And in fact, 5.3 reads, does it not, on page RO 644, members shall maintain a level of conduct in their personal and business affairs which is in keeping with the highest standards of the law enforcement profession, correct?
It does.
Members shall not participate in any act which impairs their ability to perform. I'm sorry. Do you want me to start again?
Yes, it's meant to take it from members.
I'll start all over.
Okay, thank you.
5.3 general conduct, DLT, reads as follows. Members shall maintain a level of conduct in their personal and business affairs which is in keeping with the highest standards of the law enforcement profession. Did I read that correctly?
You did.
Members shall not participate in any act which impairs their ability to perform as members of the state police or causes the state police to be brought into disrepute. Correct?
Correct.
Now, you have said that Michael Proctor brought the department into disrepute, correct? That was one of your standard sustained findings?
Yes.
And I believe it's Respondent's Exhibit 26. Just have a moment, Madam Commissioner.
Of course.
Sir, I have it in front of me now. Respondents Exhibit 26, if you have it in front of you.
I do.
It is RO 667.
Yes, sir.
Could you look at page 3 of that document, which is RO 669?
Yes, sir.
And do you see there 5.2 unbecoming conduct?
I do.
And what is the level of discipline that is titled per the regulations of the state police?
Class B.
And there's 5.21, which is also Class B, correct?
Correct.
There's also 5.2.2, which is Class A, B, or C, correct?
Correct.
All right, but 5.2.2 is not related to this, because 5.2.2 says members shall not frequent or remain in any place where they know or should know criminal activity is occurring unless in the performance of the duty or official business, correct?
I have to check that real quick.
I'm sorry.
No worries.
Back to RO 643.
Yes, that is correct.
So, and that doesn't apply in this case.
It does not.
And 5.3 above that general conduct, which we just read, that's a Class B.
It is.
And if you can look back on page 1 of this appendix for the state police rules, a first offense Class B carries no more than a suspension without pay of 30 days, correct?
Correct.
And Michael Proctor was not charged with unbecoming conduct, correct?
I don't believe he was.
Now, you also investigated Michael Proctor for this allegation of drinking on duty, correct?
I did.
And this concerned a trip to the Cape in July of '22, correct?
Correct.
And it had nothing to do with the Karen Reed case, correct?
No.
And this came up only because you started to put a magnifying glass on Michael Proctor, correct? In the investigation.
Argument.
I thought this was cross-examined, I'm sorry.
Yeah, still no argument is allowed under cross-examination, and counsel
You have
knows
to
that.
address me, not each other. Please, with the crosstalk. Okay? I'll allow him to ask questions to Rowan.
You started to focus on Michael, the department and you started to focus on Michael Proctor, correct?
No, the alcohol aspect became a focus of the investigation because that's what he testified to in the trial.
Okay, right, so he had volunteered that information?
Yes.
Okay, fine. In any event, it came up unrelated to Karen Reed's case, correct? Except it came up in the trial?
Correct, yes.
But July of '22 going
Yes,
to
sir.
the Cape had nothing to do with Karen.
Unrelated to the Karen Reed
Right.
investigation, correct.
And so the trip to the Cape wasn't to go to the beach, correct?
No, it was not.
It was with another law enforcement officer, correct?
It was.
And it was to investigate a cold case, correct?
It was, yes, it was an unrelated invest, yes.
A Cold
Cold case, correct.
What is a cold case?
So I'm not assigned to the cold case unit, but it's typically a case that has been around for a certain amount of time, and as they get older and needs lessen, it becomes a cold case. Again, that's a very rudimentary,
Term.
yes.
Yeah, okay, fair enough. In any event, he went to the Cape on business, on job duty,
Correct.
to investigate, to speak to witnesses, correct?
He did.
And in the investigation that you conducted, his interview, I should say, he was completely truthful about what occurred that day, correct?
Correct.
And all of his statements were confirmed by this auto vehicle locator device that are in the cruisers, correct?
It was.
And it was all, his testimony and his timeline was confirmed by the administrative law, correct?
Yes.
And when he went down to the Cape, he wasn't wearing a standard French electric blue state police uniform, correct?
I don't believe he was,
He
no.
would have been dressed as an investigator with a suit on, probably?
Most likely, yes.
And he told you that he went down to the Cape in an unmarked cruiser, correct?
Yes.
And he told you that he conducted interviews, correct?
Yes.
And he told you that on the way back, after working down the Cape all day, he went to dinner, correct?
Correct.
And he told you that he had 1 or 2 beers while he was having dinner.
He did.
And in fact, there's been a receipt produced from that dinner, correct? In this case?
Not to me, there was not.
We have Exhibit 39.
Is this appellant's going in?
Yes, it is. Sorry.
What number was it, sir?
Appellant's 39, APP 0263.
Okay, sir.
Have you ever seen this document?
I have not.
Okay. And you're not aware of a receipt?
Prior to today, in preparation for today, yes.
You did see it?
Yes.
Okay. And so, are you familiar with the fact that this was an investigation by the local police department concerning that day?
Yes.
And they obtained from the Treehouse Brewing Company in Sandwich a charge for $34?
Yes, I do see that, yes.
Okay. And that was for the dinner and the drinks at that establishment, correct?
That's what it shows, yes.
And there was another stop where somebody purchased something else, correct?
Correct.
Thank you. Now, Michael Proctor told you that he, by no means was he intoxicated as a result of having dinner and 1 or 2 beers, correct?
Correct.
And he never told you that the other officer was intoxicated, correct?
Correct.
And he told you also that when he went into the restaurant, he locked his firearm in his glove box, correct?
He did.
And that is appropriate per policy
It
in
is.
the law, correct?
I don't know if it was a glove box, but it was locked in an approved container.
Okay. And he did not inappropriately request overtime, correct?
He did not.
We could have a moment. Could we go to Appellant's Exhibit 38, please, which is APP 0245?
What was the exhibit again, sir?
I'm sorry, the APP number?
No,
The
the
page
exhibit.
number? Page number is 0245.
What was the exhibit number?
38, Appellant 38.
Oh, okay. I got it, sir.
All right. And so this is an email again from Suzanne Caravaggio to you, correct?
Correct.
And its subject is Proctor report, correct?
Yes.
And the date is now Friday, July 26th, 24, at 11:36 p.m., correct?
Correct.
Late at night. And so Suzanne Caravaggio says, "Hi Kevin, attached please find your report in Proctor with my latest additions and comments, questions. I'm on vacation next week and won't have access to my email, but you can reach me by phone with any concerns."
Yeah, so I'm with me.
Oh, I'm sorry.
And
I'm on vacation next week, I'm sorry.
I'll go back, I'm sorry. I'm thinking everyone has this in front of them, I'm sorry.
Sorry.
Let me go back. So this is an email from Suzanne, correct?
It is, sir.
And it's to you, Kevin Dwyer.
Yes.
The subject is Proctor report, correct?
Yes.
And it's dated Friday, July 26, 2024, correct?
Correct.
At 11:36 p.m.
Yes.
The attachment is Proctor, case number, report, correct?
Yes.
And now this is a week after Michael Proctor's interview.
Correct.
And it reads, "Hi Kevin, attached please find your report in Proctor with my latest additions and comments/questions," correct?
Yes.
It then goes on to tell you she's on vacation next week.
Correct.
So it's fair to say that Suzanne is making additional edits to your report, correct?
So again, the edits, I think it's important to point out that the edits are mainly grammar and formatting, the edits. The bulk of her, or what I'm looking for is her questions and comments about what is in my report.
Okay. But in any event, this page now, this report has now grown to 16 pages,
Yeah.
correct?
And again, that goes back to whenever she makes a comment or an edit in there, it doesn't take out the previous written, it just adds to that.
Yeah. So if you could look at page 14, which is APP 0259.
Yes, sir.
So you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. You have 11 charges there, correct?
Yes, sir.
I'm sorry, there are 12 charges, correct?
With the L, yes.
And are any of these findings different than the report you sent with sustained and not sustained findings before the interview?
Yes, it was determined that, I can't off the top of my head tell you which one, but some of them were, they covered the same aspect. So we decided rather than have two separate ones to cover the same aspect, it was combined into one charge, or one file.
Okay, but my question is, the previous document we saw with the report with 12 findings,
Yep,
you now have a document a week after the interview, it still has 12 findings, correct?
I believe yes, I believe so.
And those findings that you had proposed before the interview have not changed now with this final editing process, have
They did not.
And so then after this report's done, he's been interviewed, the report gets finished, and it goes to Lieutenant Colonel Shoemaker, correct?
Correct.
And he's the designee of the colonel.
He is.
And were you aware that Suzanne and I were communicating as early as July 22 about scheduling a trial board before the report was submitted?
No, sir.
And I assume you're not aware either of, in early August, that I was questioning about a trial, date for a trial.
No, sir, I'm not involved in those
Yeah.
communications.
Are you aware of the fact that the trial board was scheduled for September 5th?
I believe, but I can't say for certain.
I'm sorry, say that again.
I can't say for certain.
All right. Now, you're aware that after this all began, July 1st, that soon thereafter, the state police asked Michael Proctor to surrender his work phone,
Yes,
and the work phone would be one that the DA's provided him with.
yes,
And Michael Proctor voluntarily produced his work phone to the state police on July
Yes.
10th, correct?
yes,
And he also provided, John Staples, counsel for legal, asked me to have him provide his passcode, correct?
correct.
And he voluntarily gave the passcode, correct?
He did.
And so then that phone was then extracted for other information, correct?
It was, yes.
What was the purpose of extracting his work phone?
To determine if there were any other text messages in that phone that could have been derogatory about Karen Reed or other cases.
And that phone was extracted. Who's Matthew Lavoie?
He's the lieutenant that runs a unit that has the technology to get that information.
Was it he or under his direction that work phone was extracted?
Yes,
And then you saw that report, correct?
yes.
And could you look at Appellant's Exhibit 26, please?
Yes, sir.
All right. And so APP 0129 Bates number, you have that in front of you?
I do, sir.
And this is a, first of all, down the bottom, we'll work backwards. There's an email there from you, correct?
It is.
Dated August 2nd of 24 at 11:30 a.m.
Yes.
And it's to Colonel Shoemaker, correct?
Yes.
And to Captain O'Rourke,
Yes.
and to DLT Goslin,
Correct.
and to Siobhan Kelly, legal counsel, correct?
Correct.
And copied on it is Scott Cooper. Who's Scott Cooper?
He was another DLT that was an OPIA.
Okay. And also David Toomey. Who's David Toomey?
He's another DLT that's an OPIA.
All right. And the subject of this email is Proctor work cell phone, correct?
Yes.
And you say, "Good morning all. The iCloud for Proctor's work phone was looked at today. There was hardly anything on there other than some photos and videos related to evidence from the Reed trial, in parentheses, the Canton driveway and plow truck, that I believe has already been entered into the trial. There were no messages or other content. The iCloud has 5 gigabytes of storage and available, and only 7% of it was used, which supports that there is hardly anything there. From what can be seen, there is nothing currently in the iCloud that would be of concern. If anything new is learned, we will pass it along." Did I read that correctly?
You did.
So nothing was found on the work phone.
Correct.
And so next, the department decided to go a step further and do what's called a cruiser dump, correct?
Correct.
What is a cruiser dump?
So again, I'm not a technical person. My understanding is that I believe that when certain smartphones connect via Bluetooth to a vehicle, that some information can't get stored on the computers, or the vehicle's computer. So a cruiser dump is essentially taking or searching his cruiser's computer to see if there's any data from his cell phone on there.
So, I mean, to back up, the work phone would be a department phone,
Correct.
and the cruiser obviously is a department, personal property of the department.
Yes.
And so the cruiser dump would be designed to try to find something incriminating against Michael Proctor, correct?
Objection.
Well, I'll rephrase it. What's the purpose of
Sorry,
it?
Can we
sorry,
get a sidebar?
Please come to sidebar. Please come to sidebar. 7 p.m. We are back to the record. That last question will be speaking for the record. Mr. Moynihan is going to continue his question.
Thank you.
Please go ahead, sir.
All right, so I'm going to ask the question a different way, sir. What is, first of all, the state police in August of '24 performed a cruiser dump on Michael Proctor's cruiser, correct?
Correct.
What is a cruiser dump?
Again, a cruiser dump, without the technical knowledge, it's essentially to see if Trooper Proctor's cell phone had connected to his cruiser via Bluetooth, because it is known that sometimes information from a cell phone can be stored on the vehicle's computer when that connection happens.
And in this particular case, what was the purpose of performing this cruiser dump?
To ensure that we did a thorough search to find any other possible relevant text messages that may have existed on his cell phone.
And is it fair to say nothing was found?
Correct.
And so there were 2 devices belonging to the state police that were searched and dumped, correct?
Correct.
And nothing was found in either one.
Correct.
Now, is it fair to say that you were focusing quite a bit on Michael Proctor's case in July and August of '24?
Yes.
I'd like to go to Appellant's Exhibit 40. And it's a bait stand 268. Do you have that in front of you?
I do.
And so this is an email from you to Robin Marrera, correct?
Correct.
And who is Robin Marrera?
Robin Mira works in the Division of Science and Training. One of her functions is to complete the transcripts of interviews that are done.
She's the stenographer, essentially.
Correct, yes.
And it's copied to Jeremy Sweeney, and he's your colleague.
Correct.
And it's dated, is the subject, I'm sorry, it says interview transcript, and then there's the case number, correct?
Correct.
And it's dated Friday, July 19, 2024, at 6:31 p.m., correct?
Correct.
That's the same day as Michael Proctor's interview.
It is.
And it's at the afternoon following the interview, correct?
Correct.
And you say, "Hi, Robin. I uploaded an interview with Michael Proctor to your SharePoint folder. Interview was conducted today at GHQ by Sweeney and I. Others present were Sergeant Christopher Johnson, Attorney Daniel Moynihan, and Attorney Michael DiStefano, correct?"
Yes.
The next line says, "I'm sure you have others you're working on, but can this one move to the top of your list? This is a priority case for the department." Those were your words, correct?
Correct.
Now, you've told us a number of times that no one at the department told you that this case was a rush, correct?
Correct.
What's the difference between it being a priority case and a rush?
Certain cases always take priority over other cases. It is no secret that there was heavy media attention on this case. Based on that, this would be a priority case in addition to the allegations that were made. When I sent this interview, when I sent this email to Robin, this was an effort to her move this transcript to the front of the list, take it to, she has a long list of interviews that she transcribes. So it's an effort to say, this one is a priority, can you please move this to the top of your list?
So although no one told you to rush the case, it was a priority.
Correct.
Could you look at Appellant's Exhibit 45, please, APP 0283?
Yes, sir.
Now, this was introduced as an exhibit in the trial, correct?
It was.
And this is an email from Jen Prokopovich, correct?
Prokopovich, yes.
And who is she?
She works for DST.
And what is her job, duties?
One of her duties is to assist with the administrative side of the house.
And is she the person who typically sends out case reports, or IEP case reports?
Yes, typically,
And charge sheets,
correct. I believe so. That's my understanding.
and also letters of recommendation of discipline?
I believe they come from her, but again, it's not something that I'm involved in.
And you're aware of the fact that this was sent to me on August 15th,
Yes,
and that was admitted in the trial board, correct?
correct.
And there's a cover letter dated August 15th, correct?
Yes,
And this letter is from Lieutenant Colonel Shoemaker, correct?
it is,
And he is the designee of the colonel.
correct.
And on this letter, there is a recommendation for termination, correct?
Correct.
That was August 15th of '24.
It was.
And are you aware of the fact that the report was recalled after that?
I learned that after the fact, yes, at the trial board.
And this letter of termination, which was a recommendation from the designee of the colonel, was introduced at the trial board, correct?
Yes,
And you're aware of the fact that the trial board was postponed again from September?
yes,
And if you could look at Exhibit 47, please. Appellant's Exhibit 47.
yes, sir.
And this is bait stamp number APP 0292.
Yes,
And this also is another email from Jenny Proctor, correct?
yes,
And this one is dated October 29th of '24, correct?
it is.
And it says, "Good afternoon, Attorney Moynihan. Attached, please find a cover letter on the charge sheet regarding the Michael Proctor's case number," correct?
Yes,
And
And
that number again, Mr. Moynihan?
APP 0292.
What's the number?
Exhibit 47.
Are you waiting, Mr. Moynihan?
I was just making, if
Oh,
I
sorry.
may proceed.
Please go ahead.
I didn't know if you were ready.
Please go ahead.
Thank you. So DLT, this is from Jenny Prokovich, I'm sorry if I'm destroying her name, and it's dated October 29th of '24, correct?
correct.
And again, this attaches a letter of recommendation from Colonel Shoemaker, correct?
It does.
It's just a different date on it, October 29th, correct?
Yes,
And it again recommends termination of Michael Proctor, correct?
yes,
And then we have the charge sheet accompanying it, correct?
yes,
And this time, the report was included with the recommendation of termination, correct? It's not with the exhibit, but if you don't know that.
I wouldn't know, sir.
Okay, fair enough. And Colonel Noble was sworn in as the new colonel in early October of '24,
I
correct?
believe so, yes.
Now, the next step in the normal process of an IA case is after I or counsel gets report that we try to negotiate some resolution, correct?
I believe so, yes.
And then if we can't, we go to a trial board.
Correct.
And in this case, we did have a trial board. We had 3 days, correct?
Yep, yes, we did.
Could have a moment back. I'm sorry. It's Respondents Exhibit 28, DOT. And we'll go first to R0677.
Yes, sir.
And the first, are you there, sir?
I am.
Right. And so we had 3 days of a trial board in early '25, correct?
We did.
And without knowing, I would suggest January 15th, February 10th, March 13th, those sound familiar?
Yes.
So the first day was January 15th, and that's the day that the trial board was first sat, correct?
Yes.
And so, on this trial board, we had Captain Timothy Blackwell, correct?
Yes.
And he was the president of the board member, correct?
Correct.
We had Lieutenant Talitha McCarthy Johnson as the secretary of the trial board, correct?
Correct.
And we had Lieutenant Stephen Heen, H-E-A-N, as a member of the trial board, correct?
Correct.
And the location of this was at the headquarters in the second floor, correct?
It was.
And if we could look at Respondents Exhibit 25.
Yes, sir.
But I just need to find it. And this would be R0658, Bates number.
Yes, sir.
Now, this is Article 6 of the regulations of the state police, correct?
Yes.
And if you could turn, sir, to RO 6.5.1, which is Bates stamp number 662.
I'm there, sir.
6.5 deals with hearing on charges, correct?
Yes.
And it's 651, a member who has served from 1 year or more and has been formally charged in accordance with department rules and regulations shall be tried by a state police trial board appointed by the colonel/superintendent, correct?
Correct.
Now, so it makes clear that the colonel decides who sits on the trial board, right?
Correct.
And so Blackwell, McCarthy, Johnson, and Heen were appointed by Colonel North. Is that fair to say?
Based on that, but again, I'm not involved in that, in the selection process.
Well,
But yes, they were appointed as the board members.
And in January of '25, the colonel was Colonel North, correct?
Correct. Correct.
And this occurred in January of '25.
Correct.
And so policy tells us that the board members are appointed by the colonel.
Yes, sir.
And if you could look at 6.7.8, and 6.7, first of all, governs the proceedings of trial boards, correct?
Yes.
And 6.7.8 on Bates stamp number 663 reads that the trial board, by a majority vote and in writing, shall summarize the evidence and make findings of fact. The trial board shall enter a determination of guilty or not guilty for each charge specification. I read that correctly?
You did.
And it then tells us that the board shall forward their findings to the lieutenant colonel / department superintendent, correct?
Where are you seeing that, sir?
6.7, the following page, 664.
Yes.
So, in this trial board for Michael Proctor, we had 2 recommendations from Lieutenant Colonel Shoemaker as designee of the colonel, wherein he recommended termination, correct?
Correct.
Those were introduced as evidence.
Yes.
We then had a trial board that was appointed by the colonel, correct?
Correct.
And it was their decision to decide guilt or innocence.
Yes.
I have Exhibit 56. Can we go to Appellant's Exhibit 56?
No, sir.
And this would be Appellant's Exhibit 37, page 372. And what is this, sir?
This is Article 3 of the Rules and Regulations, for the regulations establishing the duties of sworn members and civilian employees.
And under 3.1, it's titled Superintendent, correct?
Yes.
And it tells us that under 3.1, the Superintendent of the Massachusetts State Police, that would be Colonel Noble, correct?
Correct.
Or Colonel Mon, remember,
Correct.
also known as the Superintendent, correct?
Yes, sir.
That he shall hold the rank of Colonel and shall be the executive and administrative officer of the Massachusetts State Police, correct?
Correct.
They shall promulgate all rules, regulations, policies, procedures, orders, and directives governing the Massachusetts State Police, including, but not limited to, discipline, organization, government, administration, training, and compensation. Did I read that correctly?
You did.
Those are all the powers of the superintendent, correct?
Yes.
And then it describes the deputy superintendent's powers, correct?
Correct.
If you could go to 3.3 on page 0373.
Yes, sir.
And this is entitled Staff Officers, correct?
Yes.
And it reads, staff officers, with the exception of the colonel / superintendent, shall be appointed by the colonel / superintendent, and shall exercise such authority and supervision over the functions of the Mass State Police as may be assigned, correct?
Yes.
And it then tells us 3.3.1, the term staff officer shall include the following ranks: colonel / superintendent, lieutenant colonel / deputy superintendent, lieutenant colonel, and then major, correct?
Correct.
And then it tells us in 3.3.2 that the colonel / superintendent shall fill vacancies in the ranks of lieutenant colonel, deputy superintendent, lieutenant colonel, and major with those officers who are eligible for such promotions, correct?
Yes.
Officers so appointed may be returned to their previous rank or to the rank of captain at the discretion of the colonel / superintendent.
Correct.
I read that correctly?
You did.
correct? And so is it fair to say that the colonel has authority to promote and demote?
Correct.
And 3.4 deals with commissioned officers, correct?
Yes.
And it tells us that a commissioned officer shall exercise such authority and supervision over the functions of the Mass State Police as may be assigned by senior supervisory members or proper authority, correct?
Yes.
And 3.4.1 tells us that the term commissioned officer shall include the following ranks: 1, detective captain; 2, captain; 3, detective lieutenant; 4, lieutenant, correct?
Correct.
It then goes on in 3.42 and tells us that the colonel superintendent shall fill vacancies in the ranks of detective captain from officers holding the rank of captain, and shall fill vacancies in the rank of detective lieutenant from officers holding the rank of lieutenant, any officer so appointed to the rank of detective captain or detective lieutenant may be returned to their previous rank at the discretion of the colonel/superintendent. Did I read that correctly?
You did.
And so in this trial board for Michael Proctor, with those 3 commissioned officers who are appointed by the colonel and who received into evidence 2 letters of recommendation of termination, it was their task to decide whether Michael Proctor should have been terminated, correct?
I believe it's their task to find guilt or not guilt with
And
the
to
charges.
make a recommendation.
Correct, yes,
And they recommended termination.
they
was
did,
it not?
they did.
Objection. Can we go to sidebar, please?
And it is that trial board, oh, I didn't know we objected.
Good afternoon, the time is now 12:46 p.m. We're back on the record, and Mr. Moynihan is going to resume his cross-examination.
Thank you, ma'am. And so DLT, we had a little break there. The trial board we talked about is tasked with deciding guilt or innocence, correct?
Correct.
And they're also tasked with coming up with a recommendation for discipline, correct?
Correct.
And it is that trial board's decision, which is the reason that we have appealed this to this body, correct?
Correct.
Now, looking back at Appellant's Exhibit 56, page 0375.
Yes, sir.
So, looking at 3.7, entitled Supervisory Members, you see that?
I do.
And it talks about the duties of supervisory members, correct?
It does.
And then on to the next page, 0375, 3.7 is continued, correct?
Yes.
And it says supervisory member, I think it should be plural, shall, and there's a colon there, correct?
Yes.
And there are numerous subsections, and it looks like there are 12 of them going on to the next page, right?
There are, yes.
So 3.7.7 says that supervisory members shall ensure that rules, regulations, policies, procedures, orders, and directives of the Massachusetts State Police are enforced and adhered to by employees under their charge, correct?
Correct.
3.7.11 says that supervisory members shall, and then it says, any unusual occurrence that may have an adverse impact upon the Massachusetts State Police shall be reported through channels to the division commander and as appropriate to the colonel superintendent, correct?
Correct.
How do you interpret that?
If you learn of something that could impact the job's duties or performance, it needs to be forwarded through the chain of command.
Okay, and then the next page, 3.7.12. Again, supervisory members' responsibility. Any unusual occurrence that may result in a question of the department's liability and/or result in heightened community or media interest shall be reported through channels to the division commander and as appropriate to the colonel superintendent. Did I read that correctly?
Correct.
How do you interpret that?
Same as the previous. If you learn of something that could be impactful, it needs to be forwarded through the chain of command.
Do I just have a moment? I may be wrapping up there, Commissioner. That's all the questions I have at this time.
All right,
Thank you,
very much.
DLT.
Thank you very much. So it's a good time to take our lunch break. It's now
12:49 p.m. We ended earlier than I thought we would. Let me go off the record.
So resume at 1:45, and we'll continue again. And I believe we'll continue with Mr. Hobby's redirect at that time. Thank you very much.
Did you say 1:45?
Yes.
There's someone at the door, sir. I don't know if they're waiting for us. Oh, okay. Thank you. So good afternoon. The time is now 1:59 p.m. We're back on the record. And Mr. Monahan, will you finish with your questions?
I am finished.
Thank you very much.
Thank you.
And Mr. Carly, do you have any redirect for Lieutenant Dwyer?
Yes, I do.
Please
Thank
go
you.
ahead.
Thank you, ma'am. Detective Lieutenant Dwyer, good
Yes.
afternoon. Could I ask you first to please turn your attention to Respondents 18, Exhibit 18, page R0500.
I'm there, sir.
All right, sir. Do you recall a series of questions under cross-examination where certain portions or certain portions of your report here, portions of paragraph 21 were read to you?
Yes,
And you were asked if they were read accurately?
correct.
All right, sir. For completeness, could we go to the fourth line down on page R0500, starting with the sentence regarding?
Yes.
You see the word regarding?
I do.
All right. I'm going to read some of these sentences and just ask if I'm reading them correctly, sir. Regarding the information about the investigation that he texted, Trooper Proctor told investigators that he did not provide specifics, besides the name of the decedent. While he may not have provided other specific case information to this friend group, he still provided information, including the cause of Mr. O'Keefe's injuries that had not been released publicly. Did I read that correctly, sir?
You did.
And continuing at that same point with the next sentence. The comment Trooper Proctor sent about Ms. Reed being a, quote, whack job cunt, unquote, is an inappropriate and derogatory comment that shows Trooper Proctor had a personal dislike of Ms. Reed. Trooper Proctor testified that his comments were partially due to his emotions getting the best of him. Police officers have to act impartially and not based on emotion. However, police officers still experience emotions based on what they are exposed to. While this is understood, it is also understood that the emotions a police officer may feel about an individual are kept in check and their actions are based on reason and fact. Did I read that correctly, sir?
You did.
Continuing with the remainder of what you wrote in that paragraph, a few more sentences, sir. Did you also write, there is no evidence to show that Trooper Proctor's personal feelings influenced the actual evidence of the case, but the language used to describe Ms. Reed is offensive and created the appearance that he was not impartial. Did I read that correctly, sir?
You did.
Continuing. Trooper Proctor's comments about Ms. Reed, quote, excuse me, I'll restart that sentence. Trooper Proctor's comments about Ms. Reed having, quote, a weird Fall River accent though, no ass, unquote, are inappropriate as they are a commentary on Ms. Reed's appearance and mannerisms. Again, these comments are offensive and created the appearance that he was not impartial. Trooper Proctor's comments, quote, she's got a leaky balloon knot, unquote, and, quote, leaks poo, unquote, are commentary on Ms. Reed's medical conditions. In his interview with investigators, Trooper Proctor acknowledged that the comments were unprofessional and regrettable. Not only are the comments offensive and unprofessional, but they are also medical issues that he disclosed to a group of people who were not privy to them. Did I read that correctly, sir?
You did.
And that was the complete portion of that paragraph, beginning with the word regarding and going all the way to the end of the paragraph.
Correct.
If I could ask you to turn your attention a few pages later to R0503. Do you see paragraph 30 on 0503, sir?
I do.
And it's fair to say you were also asked a series of questions about part of what you wrote in this paragraph.
Yes.
All right, I'm going to ask you to follow along, and I'm going to read aloud from this document, and you tell me if I read it fully and correctly, sir. After reviewing the testimony provided by Trooper Proctor related to the text messages about Miss Reed that Trooper Proctor sent, as well as information he provided to investigators, and considering the ramifications of his actions, it is clear that Trooper Proctor's behavior was unprofessional. His actions created an image that he was not impartial in his dealings with Miss Reed. It is entirely reasonable that a police officer may have personal feelings about an individual, but a police officer must act solely on fact and reason. While there is no evidence to show that the police actions taken by Trooper Proctor were directly influenced by his personal feelings about Miss Reed, his conduct demonstrated that he acted in an unprofessional manner that was demeaning to Miss Reed and cast the department into disrepute. Is that the entirety of that paragraph, sir?
It is.
Thank you. Now, sir, in the same set of documents, again, respondents' exhibits, the binder you have in front of you, could I ask you to please go to R481, please? R0481. I believe it is 15, sir.
15?
Let me confirm, please. I said 15, let me confirm, please.
It is Exhibit 15.
Thank you, Madam Commissioner. All right,
Okay, I'm there.
0481, sir, Exhibit 15. I want to ask you, before I refer you, first of all, what is Exhibit 15, just to clarify for everyone?
It is a transcript of the interview that we conducted with Trooper Proctor.
And this would otherwise be known as the OPIA interview conducted in this case?
Yes.
As part of your investigation?
Correct.
Okay. And I think earlier you testified, and correct me if I'm wrong, this interview was audio recorded,
It was.
and it was also then reduced to this transcription as well.
Correct.
During the course of your entire investigation, not just this interview, when, if ever, did the discussion or the topic of the February 8th, 2024 meeting between Michael Proctor, his attorney, and members of the department, when, if ever, during your investigation did that subject come up?
To me, during this interview.
All right. To your knowledge, or as in your training and experience, and given your entire knowledge of your entire investigation, is it your belief that this is the only place in your investigation where this subject came up?
Yes.
Okay. And with respect to these pages of the transcript, starting with 0481, there's a series of questions, both by yourself as investigator, a fellow investigator, and counsel for Mr. Proctor on this page and the next 2 pages. Is that accurate?
Yes.
All right, sir. And referring you specifically to 481 through 483, this is the part that you were referring to where this subject came up, sir?
It is.
All right, sir. And just with respect to the introduction of the subject, starting with line 4 of 481, I'm going to read it aloud, and again, if you would tell me if I read it accurately, sir. Question. So you said on February 8th, 2024, you met with Attorney Staples and Kelly and DeStefano about the text messages. Was this a breakdown of all the text messages within your phone, or just what was brought up at trial, essentially? And then at line 9, the transcript indicates Attorney Moynihan says, this was in February of 20, and then it cuts off. And continuing with line 11, you state this was after the grand jury. In terms of lines 4 through 11, did I read that accurately?
You did.
All right, continuing on, sir. The line 12 begins with question after grand jury, yes. Is that accurate?
Yes.
And then there's some back and forth between, on lines 13 through 18, there's some back and forth and some crosstalk between yourself and Attorney Moynihan. Is that accurate?
Yes.
All right. And reading the portions of lines 15, 17, and then 19 through 22, your question that's next stated is effectively as follows. And again, please tell me if I misquote anything. Question, but I mean, now he knows what was brought up in trial, so what you learned at that meeting, was it just a discussion of essentially what then came out in trial, or was it about a lot of text messages, other text messages? Did I read that accurately?
You did.
Then, beginning with line 23, there's an answer from Michael Proctor. Answer. So that February meeting was after I testified at the federal grand jury. And it was a discussion about the messages, how they were unprofessional and how they could potentially be interpreted. We decided to go into content. I've ended there at midway through line 2. Is that accurate?
Yes.
All right. And after Trooper Proctor indicated in that statement that he had decided to go into content, he takes it a different direction and says, I mean, we, Attorney DeStefano and I can't remember specifically what I shared, but they didn't really want to hear the full content at that time. We provided some examples, but we didn't go through like every single text. Did I read that portion of lines 2 through 7 accurately, sir?
Yes.
Then picking it up again with line 8, question. They didn't have a breakdown of every text. They just had what was presented at, and then you're cut off. And Mr. Proctor answers on line 10, not to my knowledge. I didn't know if they, and he's cut off, and there's some crosstalk. And picking up with line 12, with Trooper Proctor's answer, if, yeah, I don't know what was provided to them at you know what point. Did I read that accurately, sir?
You did.
All right, sir. And then on line 14, Attorney Moynihan, based on the transcript, interjects by saying, I have a question if you're done. Did I read lines 14 and 15 accurately?
You did.
And then the answer comes back from Detective Lieutenant Sweeney on line 16, yes, I'm done. And then the questions pick up in the transcript, starting on line 17. The questions now for this next portion are questions posed by Attorney Moynihan. Is that accurate according to the transcript?
Yes.
All right, beginning line 18, now under questioning from Attorney Moynihan. Question. At some point thereafter, did they get the specific text messages? Answer. Yes. My understanding is question. In March. Answer. Correct, sir. And then a question is interjected by a different participant, Detective Lieutenant Sweeney, on line 23, who got the text messages? Question, again referring to Attorney Moynihan, the legal department. Then Detective Lieutenant Sweeney interjects another question on line 25. All of them? Did I read that accurately through line 25, sir?
You did.
All right, and the last few lines here, sir. Beginning at the top of 483, beginning with line 1. Question, again referring to Attorney Moynihan. That's what you were told, correct? Answer, yes. I was informed that by Attorney DeStefano that MSP Legal met with ADA Lally and ADA McLaughlin was read in the full content of the messages. Then on line 6, sir, you interject. Yes, I think for clarification purposes, the department didn't receive anything. They were verbally told, and then you're cut off. Michael Proctor answers on line 9, correct. And your question continues, or your statement continues on line 10. What was the content of the messages? And on line 12, Michael Proctor answers, that's my understanding. Did I read that accurately, sir?
You did.
All right. Other than that portion of the transcript and that portion of the interview, do you have any personal knowledge as you sit here, sir, of what took place in the meeting between Michael Proctor, his attorney Michael DeStefano, Major Copenrath, and staff from State Police Legal? Do you have any knowledge of what took place in that meeting, other than what comes from this portion of the transcript on February 8th of 2024?
I do not.
All right. So in terms of questions that you were asked on cross-examination about, well, you weren't aware at the time, but you're now aware of that. Do you recall those questions, sir,
I
in
do.
that form?
Yes.
The answers you gave to those portions of the questions, or those questions posed to you on cross-examination, did those come from your personal knowledge or from essentially hearsay and rumor around the department?
It was from rumor.
All right. And those answers you gave to those questions, that was not based on any investigation that you performed. Is that accurate?
Correct.
All right, sir. I want to switch topics now and ask you about a series of questions you were asked on cross-examination concerning the timing of the duty status hearing for Michael Proctor. Do you recall a series of questions on that subject?
I do.
All right, sir. I want to ask you, before getting into the specifics of the timing of the duty status in this case, some general questions, if I may. First, you subjects of, based on your training and experience as an internal investigator for OPIA within the Massachusetts State Police, you subjects of internal investigations by OPIA have certain rights under the collective bargaining agreement and Massachusetts Department rules and regulations.
Yes.
All right. And in fact, during cross-examination, is it correct to say that you were asked a series of questions by counsel about some of those rights?
Yes.
You recall questions and answers related to due process rights of the subject of the investigation, things of that nature?
Yes.
All right, sir. Is it fair to say that some of those rights come into play once a subject is brought forward for a duty status hearing?
Yes, that would be accurate.
Okay. And if they have their duty status changed, if a given member has their duty status changed, based on your training and experience, do some of those rights under the CBA and under Massachusetts State Police regulations kick in at that time?
Yes.
All right, and would one of those rights be presenting the subject with evidence of the misconduct that is the basis for the allegation so that they can defend themselves during the disciplinary process?
Yes.
All right, sir. And you know that to be a right that subjects of internal investigations that you pursue have in your investigation?
Yes.
And you also know that Michael Proctor had that right as well as one of the subjects of one of your investigations?
Correct.
Did you, or to your knowledge, did anyone at the Department of Massachusetts State Police have documentation, physical evidence or documentary evidence of the alleged misconduct, the alleged text message misconduct, either at the meeting in February 8th of 2024, or the Colonel's meeting that you mentioned before, March 4th of 2024?
None that I'm aware of.
All right. And based on your understanding of the non-disclosure agreement that you described previously in your testimony, were you permitted to do anything with that information other than open an internal investigation at that time, meeting March 4th of 24?
No.
All right. Had any documentation as of March 4th of 2024, had any documentation been provided to you or to your knowledge anyone else within the department underlying the allegations of inappropriate and disparaging text messages by Michael Proctor?
No.
So there was no documentation provided to you,
Correct.
and you were the assigned investigator in that matter.
Correct.
Would, if documentation had been provided and shared with the department, would it have come to you as the assigned investigator?
Yes.
Based on your understanding of the NDA, were you allowed to share even the existence of the allegation of inappropriate text messages outside of the group of people who signed the NDA?
No.
When was the first time, sir, as the assigned investigator, when was the first time that you received actionable information and details about that alleged misconduct by Michael Proctor via the text messages that allowed you to move forward with your investigation?
When Trooper Proctor testified at the criminal trial.
As you understood the NDA, sir, you were not in a position to move forward with your investigation until you received Michael Proctor's public testimony about his conduct.
Correct.
And the department could not bring Michael Proctor forward to relieve him of duty, whether it be restricted duty or suspension with or without pay. It could not do so until it could provide the subject with documentation to support the accusation of misconduct.
Yes.
All right, sir, I want to ask you about the charges. You were asked a series of questions about Article 5. Do you recall some questions about that, sir?
I do.
I'd ask that you go please to Article 5, which is Respondents 24.
No, sir.
All right, and for council and the commission's benefit, that's R0642 is the first page. All right, sir. You have, let's call it 0642 is the cover page, 0643 is the first page of content from Article 5.
Yes.
Okay. Could you read, it's a very short, it's a very short thing, but just 5.1, if you could read, not 5.1.1, just 5.1.
5.1 is titled Violation of Rules. Members and civilian employees shall not commit nor cause to be committed any acts or omit any acts which constitutes a violation of any Massachusetts State Police rule, regulation, policy, procedure, order, or directive.
All right, sir. And could I refer you then to R0644, the next page, specifically 5.3. Do you see 5.3 general conduct?
I do.
Could you just read very briefly that one sentence, general conduct?
Members shall maintain a level of conduct in their personal and business affairs which is in keeping with the highest standards of the law enforcement profession. Members shall not participate in any act which impairs their ability to perform as members of the state police or causes the state police to be brought into disrepute.
Now I'd ask you to please, to drill down on this a little bit more. Please go to R0645. It's page 3 of that particular document. You have 0645, sir?
I do.
All right, looking down at the bottom of 0645, 5.8 is titled unsatisfactory performance, is that right?
Yes.
And 5.8.1, could you read 5.8.1, please?
Yes. Members shall maintain sufficient competency to properly perform their duties and assume the responsibilities of their positions. Members shall perform their duties in such a manner as will maintain the highest professionally accepted performance standards in carrying out the functions and objectives of the state police.
Could you then continue on to the next page, R0646, R0646, 5.8.2. You were asked a series of questions about 5.8.2 in particular as well, is that right?
Correct.
Could you just read for us the complete text of 5.8.2, and then I'll have some follow-up questions.
Unsatisfactory performance may be demonstrated by a lack of knowledge of the application of laws required to be enforced, an unwillingness or inability to perform assigned tasks, the failure to conform to work standards established for the member's rank, title, or position, the failure to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention, or by an absent without leave.
Thank you for reading that, sir. Series of questions for you about 5.8.2 in particular. Understanding your earlier testimony that you are not assigned responsibility for what charges are brought during the disciplinary process. You're only assigned to the investigation and to either sustain, not sustain, or exonerate on each individual allegation, factual allegation. Understanding that, sir, do you see the portion of 5.8.2 that says unsatisfactory performance may be demonstrated, and then it proceeds from there?
I do.
All right, sir. Is it your understanding that unsatisfactory performance may be demonstrated? What follows is a list of possible ways in which 5.8.2 can be violated?
Yes.
All right, sir. It is not your understanding that that is an exhaustive list?
Correct.
All right, sir. With respect to the questions you were asked about 5.8.2, do you recall a series of questions on cross-examination where you were asked to go down and after each one of those clauses, or each one of those sections under 5.8.2, you were asked, did you find any, effectively you were asked, did you find any evidence in your investigation to suggest that Michael Proctor violated this portion of 5.8.2? Do you recall that series of questions?
I do.
Did I characterize those fairly, sir?
Yes.
In your view?
Yes.
With respect to your answers to those questions on cross-examination, sir, can you explain how you were answering those questions? What did you mean by your answers when you did not find anything with regard to Michael Proctor's performance of his duties as a Massachusetts State Police detective assigned to Norfolk County?
Yes. So my investigation was focused on the allegations over the text messages. It was not on any aspects that Trooper Proctor took in furtherance of the criminal invest. So when I was answering those questions, I was referencing the fact that during my investigation, I learned nothing to suggest that any of his actions impacted any of the investigative steps taken during the invest.
All right, sir. Does it therefore follow from that testimony, sir, that you are saying that there's no evidence of a violation of 5.8.2 at all?
No.
Okay. With respect to, for example, in 5.8.2, failure to conform to work standards established for the member's rank, title, or position. With respect to that, going beyond just the specific investigative steps that you're aware of or became aware of during the course of your investigation, are you aware, based on the conclusions of your investigation and the evidence gathered, of a failure to conform to work standards established for the member's rank, title, or position in that broader sense of Trooper Proctor's duties?
Yes.
And earlier you asked, or you were asked a series of questions regarding your familiarity with Article 5, this document here, Exhibit 24. Do you recall being asked about your familiarity with Article 5 in general?
I do.
All right. And with respect to your familiarity with Article 5, it's fair to say that all members, not just internal investigators, are required to be familiar with Article 5. Is that an accurate statement?
Yes.
All right. With respect to all members being familiar with Article 5, and your knowledge of Article 5 in particular, sir, is there any portion of the sections we just read or any portion of Article 5 that says members shall conform in the following way except when on a personal cell phone?
No.
Does it say except when texting with one's high school friends?
No.
Does it say except when you're stressed or angry at a suspect?
No.
All right, sir, I want to change gears, if I may, and ask you a series of questions with respect to the interview that you referenced earlier. The interview with Michael Proctor took place July 19th, 2024. Is that accurate?
Yes.
Do you recall a series of questions on cross-examination from Mr. Moynihan, from Attorney Moynihan, about the timing of setting up that interview and specifically a conversation you had in conjunction with the duty status here?
I do.
All right, just to refresh everyone's recollection and the commission's recollection, what was the date of Michael Proctor's duty status hearing in this case?
It was the first.
Well,
July 1st.
so the administrative leave went through on July 1st.
Yes,
is
was
that
it the 12th, I
Sorry,
believe?
sorry. It's okay, the administrative leave went through on
July 1st?
Yes.
Okay. And the actual duty status hearing didn't occur, and based on scheduling issues, didn't occur until July 8th of 2024.
Correct.
Is that accurate?
Yes.
Okay. With respect to July 8th in particular, do you recall a series of questions from Attorney Moynihan with regard to your attempts to speak with him at or around the same time as the duty status hearing and asking him to set up a time for Michael Proctor to come in and give the interview?
I do.
All right. And sir, you were also asked a series of questions about your motivations and how much emphasis or how much importance you put on the timing of getting that interview done quickly.
Yes.
And you were also asked about how common it was, for example, for you to go to, for example, the counsel of a subject of an internal investigation at the duty status hearing in an effort to set up the duty to, that's a terrible question, pardon me, I'll start over. Do you also recall a series of questions asking about how common it was for you to approach counsel for a member at a duty status hearing to set up the interview?
Yes.
And you acknowledge that it may have happened before, but it is somewhat unusual to do so.
Correct.
Can you explain why it happened in this case, sir?
Yes. So typically, when someone gets their duty status altered, that typically happens at the beginning of the investigation. In this case, that did not happen. The investigation began in March. I learned of the content of his text messages when he testified in the trial in June. At that point, I started my analysis of the text messages to include the analysis of his pay station records at his ABL. At the time of his duty status hearing, my investigation, the bulk of it had been completed. The only piece that I had left to do was to interview Trooper Proctor. So when I approached Attorney Moynihan, it was an effort to get that interview going.
Let me ask you a couple follow-up questions, if I may there, sir. When you said you had completed every other step of your investigation except for the interview with Michael Proctor, did that include some of the exhibits we saw in your testimony yesterday? For example, your collection and analysis of the ADL data, your collection and analysis of the pay station reports, things of that nature?
Yes.
Those were all complete as of July 8th, 2024?
Yes.
In fact, every part of your internal investigation was complete as of July 8th, 2024, with the exception of the interview from Mr. Proctor.
Correct.
Was there any reason to wait to schedule the interview of Mr. Proctor, given that you were at that stage of your investigation on July 8th, 2024?
There was not.
All right, sir. Switching gears once again, I only have two more topics to ask you about. You were shown under cross-examination a series of emails that you shared with a fellow OPIA investigator, the chief of OPIA, Lieutenant Colonel Shoemaker, and Suzanne Caravaggio from the State Police. Is that accurate?
Yes,
And there were a number of emails, including emails presented to you from July 17th of 2024 in particular. Do you recall those emails?
I do.
All right, sir. And do you recall being asked a series of questions by counsel for the appellant with regard to the different permutations or versions that your report went through in July, around the time of July 17th, 2024?
Yes,
And one of those, you were asked a series of questions about a new version of your report from the afternoon hours or the PM hours of July 17, 2024, that included preliminary recommendations as to each allegation as you put forward in that draft of the report at that time. Do you recall that?
I do.
All right, sir. And do you recall a series of questions about whether or not you had reached premature conclusions in this case?
Yes.
All right, sir. Commissioner, may I approach, I handed it up earlier in the hearing when this topic came up before. The two-page document, yes. May you have a copy? May I approach the witness with a copy?
Do you have an additional?
I do have an additional.
So are you going to submit this?
I was just going to ask Detective Lieutenant Dwyer to authenticate it, and then I would be offering it as an exhibit, yes.
Please go ahead.
Thank you. May I approach counsel and the witness? Sir, handing you a two-page document, can you just take a look at that for me, please, and tell me if you recognize what you see there?
It was an email that I sent.
All right. And the date of this particular email is July 17, 2024, and specifically sent at 9:05 p.m. and 14 seconds?
Yes,
All right, sir. And if you could just look at both pages and tell me, based on your awareness and your personal knowledge, is this, do these two pages fairly and accurately reproduce the content of this email chain as it existed at that time?
yes,
All right. I would ask that this be, would it be exhibit, respondent's exhibit 37?
Can you tell me who Jeremy Sweeney is again?
Sir, would you please tell the commission who Jeremy is?
he was a DOT that was assigned to OPIA.
Thank you.
All right, sir. I'm going to refer this, well, I apologize.
I admit that is, I was on this exhibit 37.
Thank you, thank you. I'll now refer to it.
Oh, okay.
Thank you very much.
I'll now refer to it as exhibit 37, sir, for clarity. On exhibit 37, is it fair to say that this particular email was drafted after you had submitted within OPIA the new version of your draft, which contained those preliminary recommendations?
Yes,
Or preliminary conclusions, is that a fair way of putting it?
yes,
Okay. And is exhibit 37, and specifically the two lines at the top that you added at 9:05 p.m. that evening, is that by way of explanation for the new version of the draft?
it is.
Could you please read aloud the entirety of those two lines, please?
Yes. Also, and obviously, the recommendations are only based on what we know so far, and it's just a draft. They may be changed based on what we learned from Proctor.
Now, sir, I want to move slightly ahead of exhibit 37, but related questions. The interview of Michael Proctor took place July 19th, less than 2 days later after this email was drafted.
Yes,
All right, sir. And as of July 19th of 2024, following the interview, did you take it upon yourself to conduct a summary and analysis of what Trooper Proctor told you and investigators in that interview?
I did.
Did you, in fact, update your report to include the content of what Trooper Proctor stated during that interview?
I did.
And did you also check the earlier versions that you had entered into the draft copy of the report, the boilerplate that you mentioned before? Did you check that for accuracy?
I did.
Did you also have occasion at that point to analyze and incorporate Michael Proctor's testimony into your findings and conclusions in your report?
I did.
Now, do you recall a series of questions on cross-examination about how the draft copy of your report existed as of July 17th, 2024, a couple days bore the interview, and the final version as it ultimately ended up? Do you recall a series of questions about that?
Yes.
Do you recall a question specifically directed to you as to whether or not any of your recommendations changed after the interview with Michael Proctor?
I do.
All right. Can you tell us why none of those recommendations changed after the interview was complete?
Nothing was learned in the interview that changed the facts as we already had them. For the most part, Trooper Proctor had confirmed basically what he had testified to. So the sustained charges were kept. In addition, he also confirmed the charges that we did not sustain as well.
During your interview, did you have occasion to ask clarifying questions or additional questions that were not necessarily asked during his public trial testimony?
Yes.
And did you consider those questions of importance to you in your investigation?
Yes.
And with respect to those questions, were you seeking additional information and insight as to whether or not Trooper Proctor's, each individual allegation against Trooper Proctor was accurate?
Yes.
Or was supported by evidence?
Correct.
And you had the opportunity to ask all of those questions and Trooper Proctor answered them?
Yes.
All right. And did, in answering those questions and clarifying your questions as an investigator, in clarifying the answers to your questions as an investigator, did Michael Proctor give you in that interview any reason to change any conclusions that you had reached as a result of what you knew going into the interview?
No.
All right, so last topic, if I may. Under cross-examination, you were also asked a series of questions with regard to Michael Proctor sharing information about the active homicide investigation with individuals outside of law enforcement. Do you recall a series of questions about that?
Yes.
All right. And do you recall being asked if you looked into whether or not certain individuals knew certain facts as of, for example, the evening of January 29, 2022 at around 10:30 p.m.?
I do.
And you recall stating in your testimony that it was not relevant to your investigation what the pre-existing knowledge of those other individuals was.
Correct.
Can you tell us why it wasn't relevant to your investigation? What they did or did not know at that time?
Because my investigation was focused on whether Trooper Proctor was authorized or not to send that information, not based on what someone already knew.
All right, sir. As a reminder to the Commission, I know you touched on this in your direct examination. As a reminder to the Commission, who or what is the entity legally charged in Massachusetts with all homicide and unintended death investigations in a given jurisdiction?
The DA's office.
All right, so the local DA's office and jurisdiction is the legal authority by state law.
Correct.
And are troopers assigned to district attorney's offices required to follow the lead of the district attorney or his or her designees in their office for homicide investigations?
Yes.
And does that include following the lead of the district attorney and his or her office as to what is shared publicly with the media?
Yes.
Do you recall testifying in trial court in this matter?
I do.
Do you recall being asked a series of questions under cross-examination at the trial court on this particular topic?
I do.
And do you recall a series of questions designed to elicit from you whether or not you had any information about how public certain information was in the hours following the discovery of John Dee's body?
Yes.
As a result of being asked about that at the trial court, as the investigator in this matter, did you have occasion prior to today to go seek out additional information to nail down the timing of when the Norfolk County District Attorney's Office authorized release of certain information?
I did.
Sir, to your, based on the information you tracked down from the source, the Norfolk County District Attorney's Office, when did that office first make a statement about providing any information about the discovery of the deceased John Keith's body?
I believe it was in the late afternoon of the 29th.
Based on the information provided by the Norfolk County District Attorney's Office and their provision of information publicly, did they, at that time, meaning the late afternoon of the 29th, did they confirm, for example, that the deceased was a Boston police officer?
I believe so.
Do you recall whether or not on the afternoon of the 29th that they had indicated there was an individual found outside the residence, they were taken to a hospital and pronounced dead?
Yes, that sounds accurate.
Do you recall information received from Norfolk County that it was at 3:19 or thereabouts on January 30th before they confirmed that the decedent was a Boston police
Yes.
officer? Do you recall whether or not, when they confirmed that to an outside source, to the public, that the individual was a Boston police officer, did they confirm the identity of the individual, meaning not just a Boston police officer, but specifically Boston police officer John Keith? Did they confirm that at that time on the 30th?
They did not.
When was the first time that they confirmed additional details, including the identity of the decedent and the arrest of Karen Reed?
It was on February 1st.
As part of that process, and as part of your investigation overall, did you have occasion to look for any information, one way or the other, as to whether or not Mr. Proctor, as of, for example, January 29th, 2022, was authorized by the Norfolk County District Attorney's Office to reveal what he did in those text messages?
Yes.
Did you find any information to suggest that Norfolk County had authorized him to reveal that information?
I did not.
Nothing further.
Thank you very much. Do you have anything, Mr. Martin?
Just a few
Very
questions,
briefly.
Commissioner. Just to backtrack, DLT, Michael Proctor was not charged with dissemination of information, was he?
No, sir.
And regarding this non-disclosure agreement, do you have a copy of that?
I do not, sir.
Have you ever provided a copy of that to myself?
I am not.
And do you know if anyone has?
I am not aware of that, sir.
When was the last time you read it?
On March 4th.
And were you weren't given a copy, I presume?
I don't recall, sir.
You ever recall having in your possession a copy of that NDA?
On March 4th, I did, yes.
Other than on March 4th.
Not that I can remember, sir.
And so on March 4th, I'm assuming correct me if I'm wrong, you've shown a copy of it
Yes.
and you signed it?
Yes,
You read it before you signed
I
it?
did.
So your understanding today is what you recall from March 4th of 24, correct?
It is. It was a very clear understanding.
Yeah, and, but you haven't seen that document since March 4th?
I have not, sir.
And that's, and as far as you know, it's never been provided to us.
I wouldn't know that, sir.
Now, as part of that process, numerous other people at that meeting were required to sign the NDA as well, right?
Yes, sir.
Colonel Law included,
I would assume yes, sir.
Lieutenant Colonel Connors,
Yes, sir.
and others, Major Caporath, et cetera.
I would assume yes.
And so they were aware of the contents of the text messages, and they were presumably precluded from disclosing them.
Again, I don't know if they're aware of the contents. All I know is that the people in that room were aware of the existence of the text messages.
Now, you were shown what I believe is Respondent's Exhibit 26 a moment ago. If you could take a look at that and its date stamp number. So I think it's 25. Article 5. Get the base stamp. look at respondents exhibits, 643, which was shown a moment ago.
Yes, sir, I'm there.
And this is Article 5, correct?
It is.
And you were shown the category of discipline entitled unsatisfactory performance, correct? 5.8 on page stamp 645.
Yes, sir.
And you specifically read 5.8.1, correct?
I did.
And you told us that 5.8.2, first of all, that's what Michael Proctor was eventually charged with, correct?
Yes, sir.
You told us earlier that you don't decide what charge Michael Proctor or any trooper is going to be charged with, correct?
Correct.
But you told us that 5.8.2, which is very clear and specific, only lays out possibilities of examples of unsatisfactory performance, right?
Can you ask that again?
You told us on redirect that 5.8.2, first of all, that's what Michael Proctor is charged with, correct?
Yes.
That only lays out possibilities. Recall telling us that?
Yes, sir.
Okay. But 5.8.1 is pretty specific, is it not?
It is. Yes, sir.
And that's the category of unsatisfactory performance, which, as you read, members shall maintain sufficient competency to properly perform the duties and assume the responsibilities of their positions, correct?
Yes.
Members shall perform the duties in such a manner as will maintain the highest professionally accepted performance standards in carrying out the functions and objectives of the state police. Did I read that correctly?
You did.
And could you go to Respondents Exhibit 26, please?
I'm there, sir.
Date stamp 0669.
I'm ready, sir.
So page 669, date stamp. You see 5.8.1 on the category of discipline and the consequential charge.
I do.
And 5.8.1, the section we just read and that you were asked to read, what classification of discipline is that?
For 5.8.1,
Yes.
it's Class C and D.
It could be a Class C or a Class D.
Correct.
And that's at the discretion of the department/colonel, correct?
Correct.
And so Michael Proctor, if he had been charged with 5.8.1, under the disciplinary guidelines, he could not be fired, could he?
Under that one, yes, under 5.8.1.
That's all I have, thank you.
Good afternoon, Lieutenant. How are you?
I'm well, ma'am. How are you?
So I have a few questions for you. I'll begin with asking about your background. When did you first join the state police?
In 2004.
And what were your first assignments?
My first assignment was out of Leominster Barracks.
And you were just a trooper?
Yes, sir. Yes, ma'am.
And how did your career advance after that?
From the Lawrence Barracks, I was assigned to the State Police Detective Unit of Worcester County for about 6 years.
Say that slowly. State
The
Detective
State
Unit,
Police Detective Unit for Worcester County.
Worcester County, okay. Okay,
From there, I was assigned to the High Risk Victim Unit for about 4 years.
that was also in Worcester.
It was a statewide unit.
And what year did you begin that?
It would have been 2016, I believe.
So you were in Leominster for how long?
A little over 5 years.
So then, in
About 5 years approximately.
so then in 2009, you went to the Worcester County.
I was beginning in 2010, I believe.
And then after you left the high-risk unit, where'd you go next?
From there, I went to it's called the Public Response Unit.
And that's also statewide?
It's a statewide, well, it's a unit that's based at headquarters.
Which is where?
In Framingham.
So please no acronyms, and just
I apologize.
give me all the late presentations. What year did you go to the public response unit? What year was that?
2020.
2020. And you attended the State Police Academy?
I did, yes.
And Lieutenant Dwyer, what is your level of education? Where'd you go to school?
College.
College. Did you do an advanced degree?
No.
And when you joined, when you were at the police academy and after, have you had any trainings since you were hired?
On the state police?
Yes.
Yes.
Investigative trainings and
Yes.
internal affairs trainings?
Yes, yes,
Can you please
ma'am.
describe those?
There's been numerous invest trainings when I was in the detective unit for crime scenes, homicide trainings. I've been trained in sexual assault investigations, human trafficking investigations, multiple IA investigations. There's doing a bunch over the years, but those are the ones that stand out to me now.
When did you become a detective lieutenant?
In 2021.
All right. So, I just would like to go over some of the work you did on this matter. So, I'll ask you please to turn to Exhibit 19.
The respondent or the appellant?
The appellant, Exhibit 19. So this is based on Appellant 107.
You said 19, ma'am?
Yes, so it's based on page 107.
Yes, ma'am.
All right. So this is dated June the 26th.
Correct.
So is this product the result of your first draft?
No.
Your first, what is that?
No, ma'am. This product was a result of watching Trooper Proctor's testimony at the trial and the notes that I took. This was generated just to draft an idea of what the possible violations would have been.
And this, there was another exhibit where you took the notes as well. This was based on that exhibit where you submitted on just notes?
So those notes probably weren't finalized until after that one. It was this draft here was probably based off of all the hand notes that I took.
All right. Can someone tell me which exhibit was detective's notes on watching the testimony?
I apologize. I believe it was Respondent's 8.
Yes, that makes sense. Yes. So you testified earlier that you made those notes Respondent's Exhibit 8, and then this letter later after watching the testimony, live
No,
streaming?
ma'am. The notes that are the exhibit, I don't know exactly when they were created, but they were most likely created after I had drafted that document.
The notes from the video, from watching the live stream?
Yes, the notes are the exhibit. That was my final drafts. It was 2 days of testimony.
Yes.
So I spent 2 days just writing notes down. That is not what is Exhibit 8. The Exhibit 8 is me compiling all the notes that I took while watching the trial.
All right.
I also generated this document here from the handwritten notes that I took from watching the trial.
So I'll just ask you to look at paragraph number 2, which is on page 107.
Yes, ma'am.
So you have at the end of that paragraph that the conduct identified in that paragraph could be, your very last sentence says, this could be a potential violation of rules and regulations 5.23.
Yes, ma'am.
And I believe we said earlier that 5.23 was dissemination of information.
Yes, ma'am.
So I believe that is in respondents 24. Return to that, please. So that's page 652, respondents, page 652.
Yes, ma'am.
And as you look at these, it looks like it goes to about 10 sections, 5.231 through 5.2310. Which section were you considering that this could be a potential violation of?
So I'm not qualified to speak which section it is. The purpose of this document was just to highlight the possible violations. So when I pointed out 5.23, I was referencing the fact that those texts could fall under one of those subcategories in the greater category of 5.23.
Okay, so who would be qualified to decide which section it would be after you draft this?
The personnel that are involved in the process to decide discipline. That would be the GST command staff, the legal section, the department prosecutor, among others.
But if you can just please look at that page 652.
Yes, ma'am.
In looking at those sections, I mean, they're quite, I would say, different kinds of acts. Which ones would you think would match that conduct of the text messages being sent out to different people?
I mean, I don't know if I'm qualified to make that call.
How did you choose 5.23?
So I knew that he was sharing information, which would be the dissemination of information. So I know that the broader category, 5.23, the overall one, is the dissemination of information. It would be up to the person who decides the actual charges to go through that category and pick the specific subcategory.
So at the time that you wrote this document, who did you think would be the person to decide that?
So this document was not designed to recommend charges. This document was just to let my bosses know this is the violation that have occurred. These are what the possible violations may be once the invest is done. This document was generated well before a report was done or I was near the end of the invest.
All right. The same thing on paragraph 3, the same page. The last line says, this could be a potential violation of policy and procedure ADM-47 bias-based policing and ADM-18 unlawful harassment / sexual harassment.
Yes.
And what made you choose those?
Again, based on the nature of the text messages, I was just making sure that I encompassed all possible violations. Again, this document was not meant as a recommendation for possible charges. This was just to document what the possible violations may be as the invest moves forward.
And then on paragraph 4, if you turn the page, the last sentence, this could be a potential violation of rules and regulations 5.10.4.
Yes, ma'am.
And what was your consideration of including that? It's page 108, paragraph 4.
Let's look at the appropriate rule. Because that one specifies that they shall not consume alcoholic beverages. So that one was pretty simple to bend down.
So that was one you decided on your own.
There was no other option for that one, yes.
Thank you. So, the other question I had is, when you were investigating the issue of the text messages and dissemination, did you consider, did you view it as multiple violations
It did,
or one violation?
multiple violations.
How many violations do you think occurred?
Well, so there were 4 separate text conversations. So I viewed each text conversation as its own incident.
So would you consider them, so you're looking at them as 4 separate, so basically 4 separate chains,
Correct.
4 separate dates,
Multiple dates.
multiple dates.
Correct.
So you were looking at them as more than one offense then? It wouldn't be a first offense? How did you look at it?
For charging purposes?
Yes.
I don't make that call yet.
Okay. I just want to look at one more item. Do you recall this morning that Mr. Moynihan went over with you potential charges? The potential charges that you received from Ms. Cavaggio?
Yes, ma'am.
And do you recall that he described that, if you could turn to exhibit, it's actually Bates stamped 172, I believe it's exhibit 32, appellant's exhibit 32.
Yes, ma'am.
And this is where we have to look at more than one exhibit to get the information. I believe it's also respondent exhibit 26. The danger of double-sided copies. So respondents exhibit 26. Do you see on page 667?
I do.
So there are classes of guidelines,
Yes.
A, B, C, and D.
Yes.
And do you recall this morning when Mr. Moynihan went through dissemination information, which is 5.23
Yes, ma'am.
and 2, and he went through each clause with you?
Yes, ma'am.
Do you recall that for a first offense, that 5.232 is a class C,
Yes.
and that for a first offense, if you look on page 667, it's a written reprimand up to and including suspension for not more than 5 days,
Correct.
and that's for a first offense.
Yes, ma'am.
I'm not gonna look at the alcohol, the 5.10.4, but on the unsatisfactory performance, which is 5.8.2,
Yes, ma'am.
which was in terms of class A. And do you recall that under the first offense, a suspension of not less than 30 days, but up to and including termination for a first offense?
Yes, ma'am.
Mr. Carley and Mr. Moynihan, was there an ADM 47 admitted as one of the articles?
I don't believe so. Legal was produced in December, but I don't believe I was part of the market.
Yeah, it got mentioned in one of the exhibits. but it wasn't submitted. That's fine. I just know, I know I read it somewhere. Okay.
I apologize, I don't believe it was marked, but I would be happy to provide it.
Yeah, I could, yeah, because it is mentioned, and I was just wondering what it said. So I think that was the ADM 47 that's mentioned. It's mentioned in Exhibit A19 in paragraph 3. And that's what I was trying to figure out what it was. So if one of you could submit that,
I'd be happy to.
thank you. Excuse me. All right, thank you very much, Detective Lieutenant.
Thank you, ma'am.
May I ask a clarifying question?
Yes.
Only with regard to the Commission's request for ADM 47, which I'm happy to provide.
Yes.
As the Commission may be aware, the Department's policies and regulations go through multiple versions over the
course.
years. Is there an effective date, or is there a date range that I should target? I'm happy to submit multiple if necessary.
Well, I would be interested in the one in effect on the date of the letter, which is June 26, 2024. And
Thank
if it's overly, and actually the second one as well, there's two of them, ADM 18, unlawful harassment / sexual harassment. So there are two documents.
I'll produce both that were effective on that
Yes.
date. Thank you.
Thank you very much. Do you have any further questions for the Lieutenant?
I just believe, I'm curious if the department's resting, they had one witness.
Right, I think I'm just saying,
I don't have any
based on the questions I just asked, I guess that is what I meant. Do you have anything further for your comment?
Nothing for this witness, no.
And Mr. Moynihan, you arrested as well?
I have nothing else for this witness.
Okay. Well, Detective, you've had a long day, and thank you very much for coming in.
Thank you, ma'am.
You're excused. Yes. If you two may please approach. Good afternoon again. So the time is now 3:12. We're going to adjourn until October 21st, 2025, and we'll meet back here at 9:30 a.m. Thank you all very much. Have a good afternoon.
Thank you.